for coffee and cursey words, and there is so much to talk about today, mostly because the McBrooms have a bunch of lawsuits. It's a bunch. It's a bunch of lawsuits over this YouTubers versus TikTokers boxing match. It's very interesting because there are lawsuits going like this, and we get an interesting picture of what the two different sides are arguing in this, find out a little bit more information, and then we have a few little quick bits because on Tuesday, I'm like, it's not really a weekly roundup. We haven't been through a whole week, but there's a few quick bits that I'm going to get into before we get into all of the McBroom stuff. It's Tuesday. Good to see everyone coming in. I've got my coffee. I've got my cursey words. I've got my facts, not foolishness shirt, though it comes with the other F word on it as well, which I love. There's a lot going on around the internet. It's been a busy weekend. If you follow me on Twitter, you will see what I am saying over there about the busy weekend. I'm like, never miss a Sunday show, I guess. It's just. So we're going to get into our topics. I'm sure other internet drama will come up when we get to Q&A. We always get to Q&A at the end, and I'm going to leave plenty of time because the shows have been so packed lately. We haven't done a ton of Q&A. And then if you are in the replay crew, love you. There's timestamps down below for you. So you are welcome to hop over there. Are you guys, what are we drinking this morning, this afternoon, this evening, depending on where you are? Let me know. Do we have coffee? Do we have tea? What are we doing? What are we doing? What are we doing? Tell me all the things. I want to know. All right. We need to just get into it. We've got a whole lot of show to go today. So let's just roll. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. It's so good to see you all coming in. First, I need to look, we're not talking about hardcore news today on this show, but I just need to acknowledge first the earthquake in Haiti being followed up by a massive storm coming through the Caribbean always chills my heart for the people of Haiti. I grew up in Los Angeles. I have dealt with large earthquakes. It is devastating. It is scary. And though, yes, I now live in tornado country where we have different types of weather, there are alarms. Earthquakes are a whole nother level of terror. And my heart goes out for the people of Haiti. I know there are tons of charities collecting money, and it's just after the earthquake, 11 years ago, it feels like a lot for Haiti. So I know that Bethany Frankel, we talk about housewives a lot on this channel because they get themselves into some shit. But Bethany Frankel runs a really well-regarded charity and does a lot of on-the-ground humanitarian work. And her charity is on the grounds already in Haiti. So that is always an option. I'm going to put the link. I meant to do it when I populated the stream and totally forgot, but I'm going to put the link to her charity down below. So if that's something that you want to do and you're like, I don't know how to help or I don't know where to help, that is there. Also in the news, the Taliban taking power in Afghanistan. There are a lot of people covering it. It's kind of surreal. This war's been going on a lot of my life because, 25 years of war, I'm in my 40s. It's just kind of surreal to see it. And I hope that those in Afghanistan that are needing to get out and wanting to get out and hoping to get out, and that other places in the world are able to open them in with or welcome them in with open arms so that they will be safe. It is a lot going on. We are not going to ignore what's going on in the world. We are going to acknowledge it and dive directly back into internet drama. It's like there is stuff going on in the world. We see you. We know. We're diving back into internet drama. But before we get into all of the internet drama, I'm going to touch on another story that I got tagged in on Twitter a whole lot. And then the fact that the maker of my beloved car is being investigated. There's an investigation into Tesla, and I'm going to talk about that too, because I love my Tesla. And so we're going to get my perspective on it. But before we get into that, there is a new civil lawsuit going on with Nicki Minaj and her husband, Kenneth Petty. I am not going to talk about the underlying facts. They are deeply, deeply triggering and deeply, deeply disturbing regarding all of the hard R word and the SA assaults. But that is not really the heart of the lawsuit. That is the context of this lawsuit. This lawsuit is really over silencing people. The Twitter account that I was tagged on a bunch, I just want to share their account real quick because they're the ones who put up they put up this lawsuit. So I will also include the link to this. If you want to go read this lawsuit yourself, you can. If you want to see the breakdown of all of the context, you can. I'm just going to talk about the charges. But this is from the female source over on Twitter. I'm going to include the link down there in the chat, both on YouTube and on Facebook, but I'll also include it in the show notes so that y'all can go to their Twitter page, show them support, and see their breakdown of it and the entire complaint if you want to read the entire complaint. I am just going to go over some of the specific causes of action, not all of the history. There is a significant history there. This individual was assaulted by who is now Nicki Minaj's husband when she was 18, and in the years later was subsequently left New York, moved to Georgia, and said that she has been harassed and silenced by Nicki Minaj and her husband, that Nicki Minaj has used her celebrity platform to bash the plaintiff in this case, that the defendant has failed to register as a sexual offender, that Nicki Minaj has used associates and attorneys to harass the plaintiff, that they have, sent lawyers and investigators to plaintiff's house. This has been ongoing. This has been reported for quite a long time. It goes through how this has all caused substantial distress to the plaintiff, and then gets into the fact that the plaintiff moved again. And the actual causes of action in this are intentional infliction of emotional distress against Nicki Minaj's husband, Kenneth Petty, for all of the things that we just recounted, kind of the harassment, humiliation, et cetera, under New York law. Assault and battery in New York against defendant Petty. It will be interesting to see if the statute of limitations tolls for her or not. That means whether you can bring it all these years later or not. So there will be some legal wrangling over the timing of this. And so we will absolutely get into some kind of particular legal stuff to see if it tolls or not. Sexual assault against the defendant, again, we will see if this tolls or not, and allows someone who was a minor at the time to bring a civil lawsuit later, and whether they're going to apply that law here. A lot of states are expanding their laws to allow for this, so we will see what New York does underneath under their laws with regard to expanding the time frame to allow people who were assaulted or injured or battered or otherwise assaulted as minors to later bring civil suit. Interestingly enough, they are bringing a negligent infliction of emotional distress claim, again, just against Kenneth Petty, but under New York and California law. Now, this lawsuit is filed in New York, so trying to bring the laws of two states is probably not going to work very well. I will be interested to see how the courts parse that and if they allow it based on where the nexus of the actions are. They are saying that the nexus of the actions for negligent infliction of emotional distress include stalking behavior, include causing the plaintiff to move out of fear, bribing the plaintiff to recant her claims, and things like that. So I'm interested to see why they brought it under the two laws, but they brought it in New York. So there will be, though the hard thing to parse in a case like this is there is an underlying event that took place, decades ago, and then there is the current events that relate back to the older event, and then there's the legal wrangling that will happen over things like which law applies, does the statute of limitation applies, and sometimes those legal analysis can feel cold in light of how much and how charged the underlying facts can be. But the legal analysis has to happen. And the legal analysis is almost irrelevant to what the underlying charges are. It's, does this statute of limitations apply? Can you apply the law from two states? And those are the type of things we will be keeping an eye on in this case as well. Count 5 against Defendant Petty and Defendant Minaj is harassment and witness intimidation in California and Georgia, because they are saying that's where the nexus of those happened. But this is, hold on, I'm going to correct myself. I think they brought this in federal court. So they're going to ask for those choice of law provisions because of the nexus of where it happened. Yeah, this is the Eastern District of New York. So they brought this in federal court and are going to ask the district court in New York, which you can do in federal court. You can go into the federal court in New York and say, hey, these causes of actions happened here. These causes of actions happened there. The jurisdiction is here. This court has authority over these individuals, but then you have to do not just personal jurisdiction, but also subject matter jurisdiction. So there will be lots of legal, like in and out of what the law says on this and that in this case. It's not as cut and dry as the allegations are this, the law applies, because they're going to be arguing over which law applies for the harassment and the witness intimidation. And that is everything that happened after with this individual and the things she's alleging that both Nicki Minaj and her husband did to essentially get her to shut the fuck up about things that had happened to her in this 1994 plea deal with Nicki Minaj's husband and this plaintiff being the victim in that criminal case. Count 6, Nicki Minaj aiding and abetting in California and Georgia. This is Nicki Minaj helping or allegedly helping her husband with the other acts that were carried out. Count 7, intentional infliction of emotional distress against both defendants from California and Georgia, with regard to those being the nexuses for the cause of action. And then a jury demand, of course, jury trial. Prayer for relief is all the damages that are appropriate, whatever else the court finds appropriate, and punitive and exemplary damages, the punishment ones. This was filed on August 13th, 2021. I'm going to be keeping an eye on the legal of this. There are a lot of legal determinations that need to be made before this goes forward, or again, these types of things can settle out of court, but this is a fact scenario that has been going on for a substantial amount of time between these parties and this plaintiff alleging that she is being harassed. And I say alleged because everything in these lawsuits is alleged, but alleging that she's being harassed and silenced by Nicki Minaj and her husband. So if you guys want a deeper dive into that case, I will probably segment it out just due to the subject nature and get into the nuts and bolts of the law of it if you're interested. So let me know. Those are our initial quick bits. Our last quick bit is with regard to Tesla. Tesla. I'm saying it like my son used to say it because it always warms my heart. The Tesla cars have an autopilot system. My Tesla car has an autopilot system. I love my Tesla car's autopilot system. I've used my autopilot system. It's not always perfect, I'll tell you that, but I'm also always driving my car with a hand on the wheel looking at the road when it's auto driving, but the auto drive is not always perfect. The like adaptive cruise control that lots and lots of cars have, I've never had an issue with, but when it's on full auto drive, the car gets a little spooked. Like if somebody slows down to make a left turn, the car can apply the brakes maybe a little too hard sometimes, and things like that. It doesn't always account for. But the reason that NHTSA is doing an investigation into the Tesla autopilot system is because in the models, this is all the models 2014 to 2020, Tesla has sold over 765,000 vehicles that fall into this. There have been 11 accidents, some of them fatal, that involve the autopilot being engaged. And a number of these involve crashes with emergency vehicles. So I don't know if it's that the car, if they're arguing that the car didn't see that the emergency vehicle was stopped, but emergency vehicles are factoring heavily into this. I will say I have always had the issue where my car stops more than it should. I have not encountered an issue where my car stops less than it should. They say 4 of the 11 crashes took place this year alone. They include a February accident in Montgomery County, Texas, a March accident in Michigan, a May accident in Miami, and a July accident in San Diego, California. They go on to say that most incidents took place after dark, which is a factor, and the crash scenes encountered included scene control measures such as first responder vehicles, lights, flares, and illuminated arrow board, and road cones. The involved subject vehicles were all confirmed to have been engaged in either autopilot or traffic-aware cruise control during the approach to the crashes. Look, the autopilot is good. You still have to drive your car. If you think your car should be slowing down and it's not, you have to slow your car down. Like, you still have to do that as a driver. I'm just saying. But it's enough that NHTSA is wondering and wanting to look into this full autopilot driving system. Tesla describes Autopilot as an advanced driver assistance system with features such as traffic-aware cruise control, yep. Automatic lane change, yep. Semi-autonomous navigation, yep. On certain roadways, yep. Not all. The company's website explains that it offers a standard Autopilot package and more advanced package known as the full self-driving capability, and both are intended for use with a fully attentive driver who has their hands on the wheel and is prepared to take over at any moment. And the car says that to you. And the car yells at you if your hands aren't on the wheel. It wants you to like move the wheel a little bit every so often, so it knows that you are like actually paying attention. And if you do not wiggle the wheel, this has happened to me once. I was on my way down to San Diego and like singing along to music and literally not paying attention to my cruise control or to my car, but paying attention to the road, singing, didn't see it binging at me because the radio was up really loud. And when I didn't say, oh yeah, by the way, I'm here, though my hands were on the wheel and I was driving forward, it disabled both my cruise control and my autonomous driving for the rest of my drive. I was so pissed. I was like, no, because the cruise control is just seamless. And yeah, I was super bummed because I didn't hear it and I didn't like, it's like jiggling the handle on a toilet. You got to jiggle the steering wheel a little bit and be like, no, I'm here. I've never made that mistake again because it like bings at you and a little light thing flashes at you. I didn't notice. Tesla's representatives could not be reached for comment by Law 360, but it'll be interesting to see what they do with this. And if Tesla is forced to recall vehicles, if they're forced to update, they do updates over the air for all kinds of stuff, meaning my car downloads updates off of Wi-Fi to the navigation system, to the operation system, to everything. So we'll see. I'm going to be keeping, as a Tesla driver, I'm going to be keeping an eye on it, but also there's an element of how does the system work? But also how do the people work within that system? Because there's an element of personal responsibility when you're driving a car. It has automated driving, but it is not legal to automate a car and like be in the passenger seat. You can't just let that bitch drive and not even be in the driver's seat. That's not how it works. And it's not allowed by law. So there is an element of personal responsibility, but we'll see. I'll be interested to see how these evening involved crashes, if the lights were a problem with the system, if it had problems gauging the system or what have you. I'm going to peek in with the chat real quick, and then we are going to move on to the McBroom stuff. So we are going to, that is the end. Those are the bits. Those are the bits for Tuesday. Let me know if quick bits work for you on Tuesdays, and then we'll do a little weekly roundup every Friday. Because I'm trying to make sure I bring you the information that you're looking for and not just all deep dives, because we do a lot of those. We needed some quick bits. Oh, quick bit, Tati Westbrook. The court ruling from the hearing last week with regard to the requested injunctive relief from Clark Swanson, like turn over all the corporate books. It's not up on the website yet. So we'll come back to that. I know there's other stuff going on in that world. We'll talk about it during Q&A. Those were the quick bits. I feel like the quick bits work. Those were the quick bits. I saw a few super chats. I wanted to make sure I didn't miss any of them. Turtle, how does the channel perks work when you are top tier 6 months? I will be putting out a post because I realize a number of you have hit the 6 month marker. I will be putting out a post just for that tier level and let you know how it works. The post is not up yet. It's on my list. It's on my list. Jui Inna, we are taking a break from learning for exams. A break is always good. A break is always good. Jill, welcome to your first coffee and Kersey words for sure. Welcome, welcome, welcome. Ashley Vincent said, I hate this. I want to like Nicki. And then she excuses allegations against men like her husband and her brother. It's tough. I mean, the underlying facts of the Nicki Minaj case, there was a criminal case. There was a criminal plea deal in 1994. So the underlying facts of the criminal case did go through court and get dealt with. It's all the stuff that's happened after that is really, really tough. The world is different now than it was in 19. I don't need to tell you all this, but the world is different now than it was in 1994, particularly for female victims of assault. And so I think with the changing of the laws and the allowance to bring civil suits, I think this is coming into a more friendly court and jury environment than it would have years ago. And we will see what happens. There's a lot to go before we get into any facts on that case. A lot of law to go. So Debbie says, hello, Emily from Adelaide, Australia. Thanks for your awesome commentary for the masses. That's what we're here for, to understand the legal shit behind the shit we want to talk about. Sarah said, I don't use it when my Tesla is delivered. I drive my car, not my husband, not the Tesla. I drive my car too. I love it. So we'll just see. I mean, again, with the Teslas, personal responsibility goes a long way when you're driving. Spinach says, I understand that most Americans drive automatic as well. I think that is a really fair point. A lot of Americans are on auto drive and they're just like, yeah. This is an excellent point, Catboy Blep. I feel like calling it autopilot is misleading. It actually does autopilot. Like it does, but you can't just let it go. The laws don't allow you to do that. But down the road, the car can, like, it's supposed to be able to drive itself back to your house and like park itself. Like those are things that are coming. The future is now, and the car will continue to upgrade to those features as laws allow. The laws don't allow for it. I think having autonomous vehicles and non-autonomous vehicles on the road together without a driver in the driver's seat of the autonomous vehicle could definitely freak people out. But we will see. I mean, if all the cars were autonomous and they all talked to each other, maybe we wouldn't have issues, because like autonomous vehicles shouldn't cut each other off or shouldn't have road rage or shouldn't feel like they're running late. They don't have the human emotions, but autonomous vehicles have to decide if they have passengers in them. Like if a deer runs out in the road, how hard do you brake? How hard do you brake if you're going to risk flipping the car? Do you hit the deer to protect the passengers in the car? What if it's not a deer? What if it's a biker? Like there's all these decisions that a human driver might make in fractions of a second that you have to somehow move those ethics into a vehicle. So autonomous driving is quite a lot. There's a lot to consider. That's probably more than any of y'all have ever considered with regards to autonomous driving. And I'm sorry for just being like, bleh. These are the kinds of things that go running through my head. Yvonne McMeeking said, hi, Emily. I love your channel. Catching my first live as a law nerd today from Glasgow, Scotland. You rock, lady. Thank you, Yvonne. I appreciate that. If it's not Scottish, it's crap. And I'm happy to have you here. Oh, we like quick bits. We like quick bits. I like quick bits too. Yay, quick bits. Danielle asked, how do I like my Tesla? I fucking love that car. And that's not too strong words for it. I love that car. My anger with Tesla is that now the new one looks pretty rad and I kind of want the new one. But there is no reason to get rid of my car. My car is brilliant. At some point, I would love to upgrade to a longer distance battery as my battery starts to get old. I hope we can do, like, I'd love to be able to change the battery out of my car. I don't even know if that's possible. I've never looked into it. But I love my car. I love the Falcon doors. I love everything about it. I love how comfortable it is. I love how quiet it is. I love not having to go get gas. I love how technologically advanced it is. I love, look, I'm basic. I love going to Sonic for tots and being able to watch YouTube videos on my car while I'm at Sonic eating tots. Like I'll Instagram it next time I do. There's a highlight on my Instagram stories about my car. I love that my car will drive through the parking lot in the rain to come get me while I'm still under like I'm still under safety and not getting wet. I love everything about it. I love my car so much. Can your car drop you off and self-park? Yes, Missy, it can. But it can't be too far, and it's aggravated if it's a busy parking lot. Are you still going to be covering Johnny Depp? Yes, I just haven't gotten back into the suit in Virginia. It's a deep dive. So there's going to be a episode of the Emily show coming out with it. That'll be kind of a deep dive, and then we will be keeping up with it. Quite a lot has happened in court lately, moving that case forward, and I feel like it's easy. So Judy, you got this. There's an idiot in California who hops in the backseat of his Tesla. He's on his 5th car now because it keeps getting towed. If he's hopping in the back while driving, eventually the car will just go, no, you can't do that because you have to still move the steering wheel. So, yep. Wouldn't it be so cool if you could do that like Men in Black? It would be so cool if you could do that like Men in Black. It would be awesome if it would drive itself like Men in Black. It would be. Hello, allegedly, Angelo. Finally, you cover the McBroom lawsuits. I read them already, but I lack your lawyerly knowledge to understand the full extent of the fuckery. Thank you for covering this mess. It is a mess. We're getting into it. It's a lot. Y'all, it's a lot. And if you don't know who the McBrooms are, you're in good company. I didn't follow the McBrooms much before all of this. I sure didn't. And don't follow the McBrooms on their YouTube. It's not my corner of the internet. So my extent of knowledge about the McBrooms is really what's been going on lately with a lot of these things. It's like, if it's not my corner of the internet, I wasn't paying attention. I, of course, heard about the YouTuber TikToker boxing match. I'm old. I don't watch a lot of TikTok. Look, TikTok knows me. TikTok's algorithm is fucking smart in a scary way. And TikTok's like, oh, you want to see other people in your 40s who are reacting to music that you loved in the 90s, and they're reminiscing about either the My Chemical Romance of it all or the 90s pop of it all. You just want to see music compilations of people reacting or trying not to sing. That's what you want. Yes, TikTok, that's what I want. And that's what I watch. So the young TikTokers, like the older YouTubers who are all still younger than me, the older YouTubers trying to like reign supreme with the like upcoming TikTok celebrities, it feels like, I don't know, the old Mickey Mouse Club trying to fight the new Mickey Mouse Club at some point. They're all just, but the lawsuit of it all is fascinating. So Austin McBroom, let's just get into it. I should swoop it so we can timestamp it. Let's just get into it. And then I will be back for questions after we get into it. Austin McBroom and his wife, Catherine McBroom, and their company, and like his dad, are being sued 6 ways to Saturday, and they are also suing. There was a allegedly large, I think that's safe, allegedly large YouTubers versus TikTokers boxing match on pay-per-view right around the same time as the Logan Paul boxing match that recently happened. This, I think, is kind of on the heels of Jake Paul and Logan Paul making crap tons of money boxing, YouTubers like KSI making crap tons of money boxing. So I think others were like, hey, we're not quite them, but we could still make a crap ton of money just punching each other in the face. Let's make an event. Let's do a thing. So the YouTubers versus TikTokers. The first time I talked about this was when TikTok was salty that their name, TikTok, was being used in the marketing of the event. YouTube was like, no, creators on our platform call themselves YouTubers, call each other YouTubers. We're fine with YouTubers being used in the name. TikTok wanted an injunction and then it became like social media stars, whatever. TikTok got salty. It was kind of funny. But this was an event where TikTokers were boxing YouTubers. The YouTubers all tended to be, from my perspective, on the older side. The TikTokers on the younger side is TikTok celebrities. Is that what we call them? TikTok celebrities. The lawsuit lists out their followings, so you can decide. If you've not heard of any of these people, it's totally fine. The lawsuits are super interesting, and you are going to get both sides. So Austin McBroom, through his company Social Gloves, which it seems, or Simply Greatness Productions hosted the Social Gloves thing. It seems that maybe not everyone knew how much Austin McBroom was involved in the production of this event outside of being the headline boxer. There's a part of it that feels like Austin McBroom was like, I want to be the star, and then made the event around him. It was like, okay. And he got to fight, what's his face? Bryce Hall. Others also fought. We'll get into the lineup in the lawsuit. So this event was kind of thought up and put on by Simply Greatness Productions, which is a McBroom corporation. They brought in a company called LiveXLive to stream the event, do ticket sales for the event, and the LiveXLive ended up really producing the event at the end of it. They sued, the McBrooms and their company sued LiveXLive and then talked mad shit about LiveXLive. LiveXLive then turned around and sued the McBrooms for defamation and other things, the talking mad shit, and for other breaches of contract. Then Taylor Holder, who was one of the boxers who hasn't been paid, as it seems a lot of them have not, went ahead and sued Austin McBroom. So I'm going to cover these in the order they were filed. There's a lot of information here. It's all allegations. I think the most interesting interplay is we get to see like the McBrooms' perspective of the event, and then LiveXLive files their own lawsuit with their perspective of the event. And so we get both sides without anyone answering a lawsuit. I'll just put out there the next dates in all these lawsuits are late November and early December. So we've got a few months before any of these come back into court. I'm sure they're going to try to get these all into resolving. The Taylor Holder thing can't really resolve until the other two things resolve, because it seems like maybe there's no money there. We're going to be trying to follow the money. And, she's so fine, makes me wonder where the money went, is what's going on with this event. So let's pull up the first one that was filed, which was Austin McBroom and his company suing LiveXLive. Thankfully, this is at 85 pages, the longest one in the bunch. We're not going to go through all those pages. Some of them are exhibits. What I appreciate about this lawsuit, one, it's written pretty cleanly. Two, it attaches all of the contracts. We love the receipts. Thank you for bringing the receipts. Simply Greatness Productions, LLC versus LiveXLive Corporation, both Delaware corporations suing in Los Angeles over a contract that seems like it was entered into in Los Angeles over an event that happened in Miami. They are suing for breach of contract, fraudulent inducement. We love a good fraudulent inducement, don't we? Negligent misrepresentation, breach of implied duty of good faith and fair dealing. How many times have we gotten to deal with that lately? A lot. Don't worry, y'all. Don't worry, law nerds. I've got you. The next one also has defamation. Don't you worry. Don't you worry. It's there too. We can't get away from a defamation suit on this channel. No, we cannot. I didn't realize how many there would be when pop culture was the thing I was talking about the most. Accounting unfair competition. Let's get into their preliminary statement. This lawsuit centers around SGPs. I am going to screw this up all the time. Simply Greatness Productions, Social Gloves, Austin McBroom, interchangeable to me. Simply Greatness being the LLC that is, it seems to be owned and operated by Austin McBroom. Around the June 12th, 2021 celebrity they call themselves celebrities. Social media influencers. Celebrity boxing event, Social Gloves, Battle of the Platforms. Social Gloves engaged LXL, which is LiveXLive. So LXL and Caesars. Caesars is a dude. I'm confused. Paul Caesars, an individual, is being sued. Caesars, whatever. Here's where I'm confused. It doesn't seem that Paul and LiveXLive are connected in any way. So throughout this entire thing, if some of you look at this and go, Emily, this is the connection, please let me know. Because it seems like Simply Greatness tried to do what Triller tried to do and be like, "Oh, this is the fact, Triller, the fight. The fight's the thing. And so everyone we have beef with over the fight, we're going to sue them all in one lawsuit." And the very sassy federal judge was like, the fuck you are, misjoined. So I don't know how Paul Caesars and LiveXLive are related enough to both be defendants. I think on my reading of this, and maybe on my second and third and fourth, on my reading of this, that Simply Greatness needs to sue these two separately. I think they're misjoined defendants on my first look. Let me know your thoughts. I can't wait to know. They hired LiveXLive and Dude based on their professional experience, expertise to lend a trusted hand in producing, marketing, streaming, monetizing a first-class event. If you've seen Deaf Noodles cover this event, others have covered it too. There is a clip of DJ Khaled performing, but the backing track didn't play. And it's just DJ Khaled going, all I want to do is, no matter what, it's something else. So you've got to find that on the internet as well, because it's interesting. Specifically, LiveXLive and Caesars were to collectively look. That doesn't mean they worked together, though. There has to be a relationship between these two for them to be defendants. It can't be that they were both working on the same event. That's not sufficient. Dead horse. We're just going to keep going. 1, cost effectively produce an event for SGP on a work for hire basis, market and promote the event. Whenever you see the work for hire words, I hope that in your brain you're going, what now? What now? Is there intellectual property involved? Where is the intellectual property? And you start sniffing out the intellectual property. Where is it? Work for hire. Because what work for hire means is that the item that you're doing is for hire, so that the copyrights and the intellectual property in the item go to the person who hired it out, not to the employer. And we're going to get into intellectual property in this. Oh, yes, we are. But when I was first reading this, I was like, work for hire. Why do we need to make it clear that this was a work for hire? Though I don't see a work for hire clause in the agreement. I'll have to look again more closely, but I didn't see it on my initial look through. It's because they're also arguing over intellectual property in this. So it's got a little bit of everything. We got a little bit of Monica all night long. All of it. To market and promote the event, maximize revenue from various streams, including in-person arena ticket sales. And if you saw the video, if you saw any of the social media videos, the arena was not full. Pay-per-view, live stream purchases, merchandising, sales, paid sponsorships, and timely remit all accounts to SGP. LiveXLive and Caesars, I'm just going to pronounce this wrong all the time. I see a C and a Z and it's like Caesars in my head. Caesars breached. He's going to be Dude. Sorry, Paul. LXL and Paul breached their respective agreements with SGP. For his part, Paul wildly misrepresented his alleged role in producing the Logan Paul KSI pay-per-view fight. Look, the Ace family, the McBrooms, I thought were like family vloggers. But it seems more and more that Austin McBroom really wants to be a Paul brother. Like, that's how all of this feels when I'm reading through this. It's like, he's like, no, I'm just as awesome as the Paul brothers. It's like, bro, you're a family blogging channel. I mean, okay. Am I wrong? Isn't that what they are? Aren't they family vloggers? Chat, let me know. That's what I thought they were. That's what I thought the point was. For its part, LSL induced. They made them do it. Mom, he promised me if I did this, he'd do this, and he's breaking his promise. Mom. LXL induced SGP to fund a spare no cost Gatsby-style spectacle with knowingly false financial projections. However, at the beginning of this, they said that they hired them to promote a first-class event. Doesn't first class involve some kind of like bouginess? Really? Doesn't it? Kim says they were family vlogs, but shit changed. Somebody said the Holderness family is a real family channel. I love the Holderness family because I love that it's about parenting and parody and comedy, and the kids are involved some, but it's not just vlogging your kids every day. Okay. Spare no cost Gatsby style spectacle with no backing tracks with knowingly false financial projections. LXL's aim was not to be a good partner as repeatedly professed, but instead to persuade SGP to finance an over the top proof of concept that LXL could then co-opt for its own competitive purposes. LXL, you suck. I'm not saying it. That's me distilling what this whole paragraph says. These are all allegations and shade, plenty of shade in this one. They say that LXL exploited the event for its own financial gain, fraudulently concealing revenues generated from hidden agreements, including entering into a lucrative NFT agreement with Cyberneto. Magneto? Cyberneto? Let's go with Neto. It's probably not. Cyberito? Cybertino? Emily tries to pronounce shit for 4 minutes straight. An NFT agreement with Magneto and giving away free sponsorships. Despite the fact that the deadline for the event's financial settlement has long since passed, LXL refused to provide SGP with the financial accounting. If true, that's problematic as hell, leaving SGP incapable of determining the true financial state of the event. Problem, because they have to pay all of the people they contracted with. Worse, they allege, LXL has failed to turn over a single penny of the event's proceeds to SGP. Oh, we're going to get into why in the next lawsuit. They have reasons for it. That seems to be a fact that's not in dispute. That seems accurate. Conditioning the release of the millions generated from the event until SGP provides LXL with a blanket general release. Hey, this is LXL going, hey, we don't know what the fuck you were up to, but what you're going to do is release us from liability before we give you a penny. Here's the thing, though. When we get to LXL's lawsuit, you could see why that might make sense from LXL's end, because LXL is saying, yeah, but your company keeps threatening to go bankrupt, and I'm worried that if we pay you, you're just going to bounce with the money, and we're going to be liable to all the people that aren't getting paid. I can understand why they're fighting over the money. LXL's refusal to turn over the event's proceeds has left SGP incapable of paying the event's fighters and talents, all of whom are justifiably frustrated. True story. That also seems accurate. Most lawsuits contain allegations and shade, but it seems to be facts that everyone involved in this event that has not been paid seems pissed off about it. SGT's petitions this court to enforce the contractual rights, hold LXL and Paul to their contractual representations and warranties, compel them to make a full and accurate accounting, to immediately order them to release the millions of dollars in revenue generated from the event. And then they say the conduct reaches beyond mere breach of contract. They also seek relief from fraudulent inducement, negligent misrepresentation, breach of implied duty of good faith, equitable accounting, etc. They then say, with Paul's assistance, LXL effectively set up and ran a carefully planned operation to deceive Simply Greatness about the real financial performance of the digital live streams and digital merchandise at the event, and surreptitiously enter into side deals for the event without their participation. If true, that is problematic. The parties are Simply Greatness Productions, LiveXLive, and Paul, who lives in Beverly Hills, allegedly. Venue and jurisdiction. This court has personal jurisdiction over LiveXLive. This court has jurisdiction over Paul because he lives there. Venue's proper because LXL's place of business is there. Paul lives there. Simply Greatness is there. Everybody, they have Delaware corporations, but they all live in Cali. Facts common to all claims. Thank you for a fact section. SGP conceives of the event, contracts with Paul to serve as the executive producer of the event, and engages LXL to live stream the event. Conceived by Simply Greatness. Social Gloves Battles of the Platforms was to be a first of its kind, unprecedented live pay-per-view entertainment mega event. Then why are you saying that you were fraudulently induced to make it a Gatsby-style over-the-top event when you said it was supposed to be an unprecedented entertainment mega event? How are those not the same thing? You're saying you conceived of it being an unprecedented mega event, but then you turn around and say that LiveXLive induced you to make it a Gatsby-like experience. Were people in costume? Because those seem the same to me. The event was to pit the world's largest social media stars with a lineup of established YouTube stars. Old Mickey Mouse Club versus new Mickey Mouse Club. Fighting the new guard of TikTok celebrities. The event was envisioned as the perfect concoction of celebrity, influencer, social media technology, pop culture, digital marketing, and vintage Hollywood magic. If the conceived event was to have a concoction of vintage Hollywood magic, how is there fraudulent inducement again in the Gatsby-esqueness of it all? How? I can't. They're arguing out of both sides of their mouth on this, and I just can't. Because it's supposed to have vintage Hollywood magic. What kind of magic? A bait and switch? Sorry, I'm making myself giggle. It was to tap into the fighters' collective audience of 300 million social media followers. Okay. To effectuate this vision, SGP engaged with Paul, quote, social media visionary and elite Hollywood playmaker, and the self-described brainchild behind the Logan Paul versus KSI pay-per-view fight. Footnote 1. Footnote voice. The Paul KSI fight sold out Manchester Stadium in London and reportedly surpassed 1 million pay-per-view purchases. Does Austin McBroom want to be Logan Paul or Jake Paul? Which Paul brother does KSI want to be? I want to know. Which one? I think Jake, right? He wants to be Jake Paul. In exchange for his services, Paul was to receive 10% of all gross revenue received in connection with the event for the life of the event. Well, that's vague. That's not a great contracting term. What is the life of the event? How long after the event is it still alive? Including net ticket sales, net sponsorship, and all forms of streaming revenue. But gross, you just said gross and net in the same sentence. And if this is what the contracts are written like, holy shit. All of the gross revenue received in connection with the event, including net ticket sales, net sponsorship. But net's not gross. You see where I'm going. Paul was also to receive an executive producer and producer credit. On Paul's recommendation, Simply Greatness engaged LiveXLive. You're all telling me that LXL sounds like the A-word devices made by Amazon. So I'm going to just LX. No, that sounds like it too. LiveX. We'll go with LiveX. You know I mean LiveXLive. I'm just abbreviating it. In March of 2021, for the limited purpose of live streaming the event, LiveX touted its platform and tech stack that would enable Simply Greatness to, quote, harness the full power of its audience, monetize the event in a full 360-degree ecosystem. If that's not the most corporate shit you've ever heard, the 360-degree ecosystem just is it. Thankfully, the parties' March 11th, 2021 confidential and binding term sheet is attached as Exhibit B. It's not even redacted or anything. It's just all there. LiveX was to provide its, quote, 360-degree ecosystem for the event on an exclusive basis, including event ticket sales to customers. Remember that. Remember the ticket sales part. It's going to come up in the next lawsuit. Event ticket sales to customers, marketing support, production of the live stream event, distribution to the event customers' mobile phones, their platforms and channels through to the internet via streaming technology, merchandise sales, special meet and greets with talent, backstage access for hosts and correspondents, curation around the event, and high-end support and service to customers. They were also committed to developing, quote, an impactful plan to help maximize awareness and sales. That comes up in the next lawsuit as well. In exchange for these services, LiveX was to receive a payment processing fee as well as a per ticket transaction and service fee. They were to raise the ticket price so that when anyone bought a ticket, that the ticket price was bumped above what they were paying to Simply Greatness, and that additional bump was the pay for LiveX's participation. LiveX projects that the event will be the highest selling pay-per-view event of all time. Yet they scheduled it like a week after the Logan Paul fight. Because apparently Austin McBroom wants to be a Paul brother. LiveX and Caesars announced the ambitious aspirations for the event in a March 18 press release, saying that this promotion is the accumulation of every key learning I've experienced. God, that sounds so corporate too. Of every key learning I've experienced being at the very forefront of the social media industry, including the first ever social media pay-per-view event, Logan versus KSI, which I helped put together. Okay, Paul, we see you. There we saw that the rabid international fan base of these social media moguls, KSI is based in London. So it's like across the pond battle. Drove more audiences and sales than traditional legacy professional athletic events. I think the world underestimates how much people want to see Paul brothers get punched in the face. And I think Logan maybe not Logan. I think Austin maybe underestimates that part of the driver to the Paul events is the Paul brothers. Like them or not, it's not that they are YouTubers, is that people want to see them get punched in the face. There's a big driver to that. And also, I think they hyped the event way better than Austin did. I mean, the Paul brothers know how to drive drama on the internet the same way other social media trolls know how to drive drama on the internet, but Paul and KSI know how to drive drama on the internet to bring awareness, where with the McBroom stuff, I think a lot of people were just like, I just don't care. LiveX shared Paul's enthusiasm. The controversial, I don't know anything about why this dude, Robert, is controversial, but okay. The controversial chairman and CEO joined in the press release stating, quote, "We are thrilled that LiveXLive has the opportunity to be part of delivering the biggest global pay-per-view in history." To this end, on April 22nd, 2021, LiveXLive furnished an initial financial model projecting 1 million pay-per-view purchases, streaming sales in excess of $57 million, plus an additional $5 million in sponsorship sales. Throughout the planning process, LiveX's senior-most executives continuously projected that 1 million pay-per-view purchases was not only obtainable, but that anything less would be viewed as a disappointment. Paul reiterated the reasonableness of LiveX's $62 million financial projection, noting that the event's attributes would enable it to eclipse the Logan Paul KSI pay-per-view sales. How many times are they going to talk about Logan? Logan's like lawsuit famous, yeah. Ugh. They say that the bullish projections induced SGP to overextend itself and commit to larger than necessary production. Half of this lawsuit, that's an exaggeration. A fair portion of this lawsuit talks about the vision, and the vision being a first class old Hollywood extravaganza. And then you're trying to say that the projections are what made you commit to a larger than necessary production. It seems like the conception of this was a larger than necessary production. The conception of this was bigger than life. Ugh. That makes you larger than life. Crap, we've gotten into the Backstreet Boys today. It's going to be that kind of a morning. They go on to say that LiveX's oversized projections resulted in oversized expenditures. Really? Okay. It's your lawsuit. Go off. LiveX's role morphs from streaming partner to producer, acts as if it were the owner of the event, urges, this is a lot of sentences all rolled into one. Urges Simply Greatness to spend an oversized budget to boost future events. There's the whoop. There it is, by the way. The future events is the whoop. There it is in all of this. As the event began to unfold, Paul served as executive producer in name only. Yeah, Paul bounced. In truth, he produced nothing. Despite LiveX's work for hire contract status with Simply Greatness, LiveX stepped in to fill Paul's void. Why are these two defendants in the same lawsuit then? If Paul was contracted separately and has nothing to do with LiveX, then these two defendants shouldn't be in the same lawsuit. Go sue Paul elsewhere. Or go sue LiveXLive elsewhere. Paul shouldn't be in this, which kind of answers one of my later questions, I think. LiveXLive's role drifted from streaming distributor to co-producer to producer. They commandeered Did they commandeer the production of the event if the other dude bounced? They say LiveXLive commandeered the production process and dictated the event budget, repeatedly demanding that the production budget be no less than $4 million and constantly pushing for an increase in the scope of the event and size of the budget. LiveX steadfastly refused all of SGP's attempts to streamline production costs, insisting that every dollar was critical to a successful event. They're saying LiveX induced them to spend more than they wanted to spend, that the CEO was pushing for a higher spend, 7.1 mil budget is critical, and continued to try to induce Simply Greatness to spend more by referencing LXL's desire, quote, to help any way possible in the partnership. Comforted, they say, by LiveX's repeated representation that it was a partner seeking to forge a long-term relationship and in reliance on their financial projections, Simply Greatness agreed to finance the envisioned over-the-top spectacle. They keep saying that it was LiveX that envisioned the over-the-top spectacle, but they also in the same document describe that they envisioned an over-the-top spectacle. I can't get off this point. They keep belaboring it that it was the live streaming partner's vision, but when they say their vision of the event was a one-of-a-kind, first-class event that was going to be better and greater and bigger than Logan's event. You can't argue both things in the same document. It just it does not fall friendly on my ears. It's just be clear one way or the other. Hey, if they had argued, look, we envisioned an event that was going to sell really well online, and we didn't need it to be a huge production thing because it was going to sell really well online, and it's the first of its kind. So we were envisioning a well-executed event, a tight, well-executed event. That's not what they said. They said old Hollywood magic, which is not a tight and little event. They say that LiveX's repeated assurances of great commercial success induced them to finance the spare no cost production, featuring the world's most recognized social media stars, top music acts, including Migos, Lil Baby, Trippie Redd, other luminary participants ranging from the legendary "Let's Get Ready to Rumble" ringside announcement Michael Buffer, not to be confused with Bruce Buffer, but either way, Paige Van Zandt, ringside analyst, and celebrity host Charlemagne the God. However, they would have had to have signed off on all that. We're going to keep going. Hindsight has revealed that LiveX was constantly pushing for higher and higher production budget, not because it believed the sales projections it was fraudulently feeding to Simply Greatness, but rather because it wanted an expensive proof of concept showcase by which it could enter the marketplace as Simply Greatness's competitor and gain leverage with third parties in the future. The CEO tacitly admitted such during a recent earnings calls, noted that LiveX wanted to prove that LiveX's, quote, production and technology were going to work. They then quote the Q4 2021 earnings call, There is a full transcript attached that said, "We proved to perfection and everything worked perfectly. We did our biggest revenues in the history of the company, and we immediately announced the next social media pay-per-view fight, one right behind it, right because of that success." Oh, don't kid yourself. LiveXLive is now producing social media boxing events and has cut Simply Greatness out of it. So take that as you will. We're going to get to those in a minute. Exhibit D is the earnings call. And I can understand the chafe that would come is like, oh, this is my event. And at my event, you're selling your own shit at the end of the event. Like in the entrepreneur space, if you did this as like a speaker without having conversation and you got up on stage at someone else's event and then sold your event from that stage, it would not sit well in the industry. There are some stages you're allowed to sell, most that you are not, but it would just, you don't use someone else's event to sell your own shit, is what I'm saying. LiveX signs side deals with third parties as if it were the owner of the event. Despite being a work-for-hire producer, LiveX unilaterally entered into event-related agreements without Simply Greatness's knowledge or participation. Look, this is one of those allegations where if this happened, it's not going to be hard to prove who signed the contracts and what contracts are they. And if there's agreement, then those agreements would have been noted. If it was run by them and they said, yeah, sign it. But that will be pretty easy to flush out. The problem for me in this is that they say by way of example and get into the Hard Rock Casino. This is addressed in the other lawsuit that we're going to get to as well. They say by way of example, without SGP's participation, they signed a venue agreement with longtime business partner, the Hard Rock Hotel and Casino in Miami Gardens, Florida. Hard Rock Agreement 3. Footnote voice. This venue commitment was a questionable decision because the June 12th, 2021 event would follow on the immediate heels of the June 6th Floyd Mayweather-Logan Paul fight at the same venue, potentially saturating the market and cannibalizing the market for in-person ticket sales. It's not that Austin wants to be a Paul brother. It's that LXL made that agreement. Pursuant to the Hard Rock agreement, Hard Rock was to account for all in-stadium ticket purchases to LiveX, not to Simply Greatness. As a consequence, Simply Greatness is and remains dependent on LiveX to receive an accurate accounting of all in-stadium ticket and merchandise sales. They're arguing that they don't know even how many in-stadium sales there were. In exchange for securing the event's venue, LiveX demanded 25% of all revenue generated from the Hard Rock agreement and above-market commission. Simply Greatness has never received a final copy of the executed Hard Rock agreement, they say. In addition to unilaterally selecting the venue, they also made the agreement with Cybertino, a leading purveyor of NFTs. We've talked about NFTs and other times at this on this channel. I'm not going to take the time to describe NFTs, but they're saying that the event producer made an agreement to sell NFTs around the event without authorization. I mean, that's what unilateral means. They say that beyond the event, Magneto agreed to sell event-specific items, including prescribing a specific guaranteed amount of multi-million dollars. Including prescribing a specific guaranteed amount of the multi-million dollar advance of the event, creating exclusive pay per ticket NFTs, 3D interactive coins of each fighter that turned gold for the win. Has anyone seen these NFTs on social media? Please tag me. Now I'm curious. Creating NFT trading cards for Austin McBroom, Bryce Hall, and several other fighters. Someone would have had to have agreed for their likenesses to be used in this way. Or not, and maybe that's why it's here, but they don't seem to be suing Cybertino over the use of their likeness or selling of their likeness in an NFT. I think Austin wanted a trading card of himself. Bryce Hall probably did too. As well as limited edition NFT event-specific sneakers for McBroom and Hall. So fake digital sneakers. Despite the fact that LiveX never secured the fighter's name and likeness rights. Yes. Yes, I did forget that was the next sentence. Footnote 5. Footnote 5 is an article where LiveXLive announces the NFTs. And if you guys want to see that, I'll just drop this in the chat if you guys want to see this later, and then we can drop it in the description as well if you guys want to see the press release about the NFTs out of your own curiosity. SGP demanded that LXL share with SGP a copy of the Magneto agreement. LiveX has steadfastly refused upon flimsy excuses. Look, man, of everything in here, what you can't do is sell rights that you don't have. They go on to say, ultimately, as further described, Simply Greatness settled for LiveX's contractual representation that, quote, an additional $1 million would be received and allocated once 150,000 pay-per-view tickets were sold. The true reason why LiveX, they allege, refuses to share the Magneto agreement is that LiveX received amounts far in excess of $500,000 that it represented and warranted to Simply Greatness, including but not limited to far larger advance, hundreds of thousands of dollars in revenue from the resale of event-specific NFTs. Indeed, in a recent earning call, and that's linked below, in discussing the event, it was stated, quote, we delivered over $2 million from Hard Rock from the stadium pay-per-view. We've now crossed over $3 million in NFT money, paid for upfront in cash for delivering the quality of content and talent that we have in our platform. But who signed all the talent deals, though? Because it seemed to me that the McBroom company, Simply Greatness, was the company that secured all the talent deals, not LiveX. So if LiveX is saying in its earnings call that they got paid upfront in cash for the sale of the NFTs based on the talent they have in their platform, the talent they have in their platform has nothing to do with this event, because it seems that Austin McBroom's the one who secured the talent. So while I will rip on him all I want, it seems disingenuous without more for LiveX to say that they made $3 million in NFTs and got paid cash for the NFTs based on their own talent when Austin McBroom was the one securing those fights. So of all of the points in this so far, the NFT issue to me is one of the bigger issues, but I am then confused why there isn't a lawsuit also against the NFT company if they were selling NFTs that they didn't have the likeness rights to sell. Why isn't that lawsuit happening? Where's that? What are we missing? Something's not, I'm trying to follow the money here, people, and something's not adding up. They go on to allege that LiveX is double dipping and demanding a hefty above market finder's fee for the event and for the Magneto agreement, despite being entitled to 75% of all revenue generated from the Magneto agreement in connection with the event. Simply Greatness has no visibility into the terms of the agreement, aside from the limited representation and warranty. That is a big problem. That is a big problem. I would be pissed if you hire someone to do an event and then they're selling things off of the event. It's a problem. No matter how much I think LiveX also has issues with the McBrooms. This all needs to go to mediation. LiveX also entered into a series of event sponsorship agreements without Simply Greatness's knowledge or participation. By way of example, LXL subsidiary Podcast One entered into a sponsorship agreement with Start Hero. LiveX also entered into an agreement with E11 Even Vodka without their knowledge and participation, and now professes that this was a $0 sponsorship. So they were giving out sponsorships, which is also a problem. If true, LiveX did not possess any contractual right to furnish free sponsorships or leverage their event for its own commercial advantage, and giving Podcast One a sponsorship or a sponsorship agreement on the back of this is also a problem. They say that they amend the contracts, and then in the amended contract, this got amended because Paul bounced. So they amended to include production services where LiveX would then oversee the physical production of event, prepare for the event for broadcast distribution, provide Simply Greatness with the same access to real-time pay-per-view sales activity and all underlying source data, account to Simply Greatness for all pay-per-view sales of the event, account to them for all merchandising sales of the event. So it looks like they then modified the contract. Did they say the date? To reflect LiveXLive's expanded role, Simply Greatness and LiveX entered into a production services agreement negotiated over the span of weeks. Production service agreement was not fully executed until June 9th on the eve of the June 12th event. It's interesting because LiveX has a totally different take on that. Additionally, the production services agreement makes three distinct representations and warranties. They're saying they're warranties. The LiveX is going to argue they're not warranties. Quote, $1 million allocation at 150,000 pay-per-view ticket sales, the addition of SGP as a signatory to all of the sponsorship deals. Yeah. LXL represents and warrant that it should add Simply Greatness as a signatory party to every sponsorship agreement that it entered into in connection with the event. They shouldn't have entered into any without Simply Greatness. That's problematic. Real-time access to source data for pay-per-view ticket sales with respect to the funds from Braintree related to pay-per-view sales due to Simply Greatness upon release by Braintree. LiveXLive represents and warrants that it has provided Simply Greatness executives with the same access to real-time pay-per-view sales via Tableau that LXL receives. Pre-event hype and performances. The event was preceded by significant media coverage. I mean, who defines significant? A May 17th press conference at Fred Siegel, West Hollywood. Why? Why is the press conference at Fred Siegel? This is not Clueless. It was marked by a brawl between Austin McBroom and Bryce Hall. If you want to know how fake the internet is, the fact that they got into a fight at the press conference is good hype. And that led to significant internet buzz. Yes, it did. 2 weeks later, an impromptu fan meetup for Austin McBroom was flooded by fans, temporarily shutting down Rodeo Drive. Notice they didn't say significant internet buzz on this, because as I remember it, that received significant internet criticism. The pre-hype buzz suggested that the event would match the financial projections. By objective measurements, the event was a success. Okay. This lawsuit says, by all objective measures, the event was a success. LiveXLive's lawsuit says, by all objective measures, this event was a steaming failure. I'll let you decide. Headliner Austin McBroom, 20 million YouTube followers, 7 million Instagram followers, 6 million TikTok followers, delivered a third-round knockout of Bryce Hall, 2.4 million TikTok followers, 8 million Instagram followers, 4 million YouTube followers. This fight was preceded by, and then we go through every single other fight and how many followers they have. Gibbs, 2 million YouTube followers, defeat of Taylor Holder at 19.5 million TikTok followers. Vinny Hacker's 6 million TikTok followers, defeat of Deji, 10 million YouTube followers. The night's sole win of Team TikTok. Even in the lawsuit, they shade the TikTokers. They're like, Deji dropped the ball. YouTube smashed. We have to, like, did Austin McBroom say to his lawyers, you have to make sure it's very clear that YouTube smashed TikTok? Like, it has to be clear that the YouTubers are more powerful than the TikTokers. And then they just go over and over all the FaZe Jarvis and Michael Lee and whoever these people are. And then they talk about the interspersed between the fights were performances by A-list musical talents. Go find the video of DJ Khaled's performance. And I like DJ Khaled. I think he got done dirty by the production of this event. Him going, all I do is, no matter what, it's just, there's no backing music at all. Despite missing its projections by over 85%, LiveXLive touts the event as a success, and announces its own competing pay-per-view event. Okay. Despite massive objective shortfalls, LiveXLive released a post-event press release boasting that the event was monumental and delivered over 3.5 billion total social media impressions. Impressions aren't sales, boo. And the thing that's so amazing is that in LiveXLive's lawsuit that we're going to get to next, they clown on Austin McBroom for talking about impressions and not sales. Like, impressions and sales aren't the same thing. And in their press release, it's alleged, well, it's attached as Exhibit G, that they're bragging about these social media impressions. But LiveXLive in their lawsuit is saying that this event was a failure. Apparently, on their June 16th press release, what they said was that it was a monumental event with over 3.5 billion impressions. Was that everybody tweeting about the event? Or is that where they're getting the impressions from? In pushing for Simply Greatness to join the press release, LiveX celebrated the event's success and highlighted Simply Greatness's alleged benefits that resulted from the event. It was written, for example, that an amazing event was created. The feedback has been universally positive in a way that I've almost never seen. The event will, I feel, change the course of the music, sports, and entertainment worlds. That's a lot. You now own a piece of IP that is truly valuable. That goes to the NFTs. I am convinced that we have proven once again that we are the best in the world at producing these events and will continue to work on many more. We're so great. We have our own event. I'd be salty too. If I was Simply Greatness, the selling of another event and the back patting when they went and then sued Austin McBroom over this event, saying that the event was a failure, I would be salty about it too. They then go on to say that to date, LiveX has refused to provide a full accounting, including the revenues generated, that they have, that Simply Greatness is therefore unable to negotiate with or pay investors, talent, and fighters, all of whom are frustrated. They then go on to say that LiveX has spun its deceit and contractual failings with Simply Greatness into a proof of concept triumph for itself, and has recently announced that it entered into the marketplace in fall 2021 with a pay-per-view all-female version of Social Gloves called Self-Made KO with female fighters. In announcing their launch of Self-Made KO, the CEO stated, quote, "We saw firsthand the amazing appetite fans have for pop culture battles." Celebrity boxing has been going on for a very long time. It was really funny on South Park. An event that brought the best aspects of entertainment together for one amazing night. And then they included that Variety article as Exhibit H. Why is Variety quoted in so many of the things I'm covering? I don't, because pop culture. The causes of action in this are breach of contract and the term sheet. Hey, you were supposed to do the things, you didn't do the things, you haven't provided an accounting, you haven't paid the money, you were supposed to pay over money within 30 days of the fight, you're still holding the money. LiveXLive says in its own lawsuit, yeah, we're still holding the money for other reasons. Breach of contract with regard to the production services agreement, that they entered into agreements that they weren't supposed to enter into. They did it unilaterally. That is problematic and is one of the things that without more, this isn't even addressed in LiveX's lawsuit. But you can't just go rogue and enter into agreements. Breach of contract against Paul. I don't think the Paul stuff should be in here. This should be a separate suit against Paul elsewhere. We'll see what a judge does with that and if it's asked to be severed out. Fraudulent inducement against LiveX. Hey, we told you everything was going to be great and we made you spend all this money. And they are saying that LiveX was lying to them about that. Negligent misrepresentation, more of the same. Breach of covenant of good faith and fair dealing. What you can't do is go and make deals behind our back, sell your own event, and not deal with us honestly and in good faith. We covered the covenant of good faith and fair dealing quite a lot. Don't be a dick. Do what your contract says and do it in good faith. 6 cause of actions for an accounting. We want to see your books. Like, what the fuck happened? They say that Simply Greatness needs a full and final accounting of all pay-per-view transactions to definitively confirm that only 136,000 pay-per-views were actually sold. And this is kind of the crux of this thing. how many pay-per-views were sold, how many NFTs were sold, and how many in-stadium tickets were sold. Simply Greatness is saying they don't have access to that data, and it's their event, and they should. Also well taken. Eighth cause of action, unfair competition. Hey, you've stolen our intellectual property. You made this agreement with Magneto and done all this stuff that you can't do. And then they are praying for an amount of damages proven at trial, punitive damages, cost, disbursement expenses, attorney's fees, etc. They then attach all of the receipts, the agreement, which says essentially what they say it says. This was signed back in March by Alan McBroom. The confidential and binding term sheet, this is the breakdown of the whole thing and the commissions and all of it. Again, represents basically what they say it represents. This was entered into March 14th with Paul and LiveXLive. So both of them entered into this agreement. Having them both on this one agreement is very interesting, which might actually pull them both in because now they have this binding term sheet to get it done. That might be enough to pull them in together. We'll see. This is the press release. Y'all saw this all over social media. You pick and you pick. It's like the fans pick. Anyway, this is what TikTok was salty about. That. And this is presented by Social Gloves. And at the time, people didn't realize Social Gloves was Simply Greatness Productions, which is essentially Austin McBroom's company. That bit was kind of left out. The earnings call transcript, and this is literally the entire transcript of the earnings call. We're going to jump into the next lawsuit and go over it because, we're like an hour and a half in. It's a lot of lawsuits. It's a lot of lawsuits. So that's Austin McBroom suing LiveXLive. I'm going to swoop because we got to get to LiveXLive suing Austin McBroom. So Austin McBroom sues LiveXLive over the breach of contract and everything else that we just covered. This lawsuit, I'm scrolling back up to find the date it was filed because I've already forgotten. This lawsuit was filed July 21st, 2021. And the next one came in hot. So LiveXLive turned around and sued Austin McBroom for defamation, among other things. That was filed August 3rd, 2021. There is actually a new update to this that was done today. Let me pull that up first because it's in here, but it's like not all the way official. Today, they went and amended this to name the first doe, and the does are the unknown, like a John Doe and a Jane Doe. Does are the unknown parties. It's like, hey, you might have been involved in this. We're not sure exactly who you are, but we think others are involved. So, no, this wasn't today. Pardon, August 9th, 2021, this was filed. That the first amended complaint was naming doe number 1. Upon filing of the complaint, plaintiff was ignorant of the true names of the following defendants, and that doe number 1 has now been named as Catherine Paez or Catherine McBroom. So we now have Catherine McBroom officially named in this lawsuit between LiveXLive, their corporate entities, and the McBrooms and their entity. So LiveXLive, who produced the event, is suing Austin McBroom, Simply Greatness, Alan McBroom, and Catherine McBroom for defamation, violation of Business and Professions Code, breach of contract, fraud, intentional interference with prospective economic advantage, injunctive release, and injunctive relief. Injunctive relief was added in this first amended complaint. This is the first amended complaint from August 3rd. The original complaint was filed a little bit earlier than that. Let's look up the date just real quick. Let's just satisfy my own curiosity when the initial complaint was filed. July 22nd is when the initial complaint was filed from LiveXLive against Austin McBroom. Let's pull this back up. Let's get into what they have to say. Wait, this is the Simply Greatness one. Just kidding. This one. Let's get into what LiveXLive has to say. Let's get into their side of the thing. They start with jurisdiction. Not even facts, right into jurisdiction. Everybody's in California. It's fine. Part of me was like, okay, this is covering mostly the same parties. I won't be surprised if we see these all merged into one court because it's dealing all with the same course of events. It could have been cross-complained. I don't know why they chose not to cross-complain it. Like, they're already all in the same courts. This is all filed in LA County. I don't know why they didn't choose to cross-complain it. We'll see. I think it's all gonna end up in the same court down the road anyway. The parties are LiveXLive Corp, LiveXLive Media, which seems to be their parent company. Pardon me. Austin McBroom, Simply Greatness Productions, Alan McBroom, and Catherine McBroom. And then other does 1 through 20. They then get into the facts with no heading, which just absolutely bugs the shit out of me. It's like, where are our headings? Where are the headings? These are the parties. Parties. They get a heading. Operative facts, relevant facts. Where is my heading? Also, why are we on 28-line paper? When the lines don't line up, look. 27 is there. The line should line up to it. When the lines don't line up, it means you're using the wrong paper. We know how strongly I feel about the little things. The little attention to detail matters. Says the individual who sometimes misspells things in her own thumbnails. Yes, I get it. I'm not filing in court. Oh. On or about March 14th, 2021, Simply Greatness entered into an agreement with LiveX to use LiveX's platform staff to facilitate a live streaming and distribution of a pay-per-view event known as Social Gloves YouTube versus TikTok. This agreement was captioned confidential and binding term sheet. They didn't attach it, but we have it in the other lawsuit. Prior to the term sheet being finalized, Austin and Simply Greatness represented to LiveX that their anticipated viewership of the event was 2.2 million paying audience members. 2.2 million paying audience members. And then they go on to say over 5 million pay-per-view tickets. What? In the term sheet, Alan McBroom and Simply Greatness required that there be a provision indicating that Simply Greatness expected to sell over 5 million pay-per-view tickets to the event and had no intention of capping the number of consumers purchasing the stream. Now, in the McBroom lawsuit, they keep saying Simply Greatness gave us projections that there would be 1 million in sales. So it feels like they're just making up numbers or pulling them out of a hat. Prior to the term sheet, they're like, no, we think there will be 2.2 million paying audience members. Still higher than the 1 million that Simply Greatness projected. But then they said that they expected it to be over 5 million pay-per-view tickets. So how in their lawsuit, the McBroom lawsuit, how are they saying Simply Greatness had all these massive projections when that projection was 5 times smaller than what they're saying the McBroom's own projections were? You can't argue that LiveXLive induced you to spend all this money when their projection was 5 times less than yours was. Okay. LiveX entered into the term sheet wherein consideration paid to the event was based on the 15% added to the face of the ticket or bundle and passed on to the ticket buyer, which meaning you as the buyer paid more so that LiveX got paid. The number of tickets sold would there be a product of the adequacy of the marketing orchestrated for the event. The term sheet provided that Simply Greatness's public relations firm and Simply Greatness, quote, shall collaborate in a meaningful consultation with LiveXLive to develop and execute a detailed promotional plan for the event, and which leverage and retained talent consistent with the talent deals. Simply Greatness would use its best efforts to ensure that the talent is required to actively promote the event and that their participation in the event on all social media outlets. This is in the agreement. The agreement says that Simply Greatness has a responsibility and an obligation to promote the event in collaboration with LiveXLive. It's something that LiveXLive takes huge issue with in this suit, saying that Simply Greatness and Austin McBroom did not, in fact, uphold that end of the agreement. And this is pre-event. Most of the McBroom lawsuit is like everything that went down post-event, and then those side agreements that they're alleging. This is like, no. This addresses side agreements, none. But this is like, no, you didn't market the event in collaboration with us. They go to say that defendants promised to collaborate with LiveX and utilize LiveX's extensive experience and the collective knowledge of its marketing team to develop a tactical strategy in order to ensure that the event performed as planned in the event deck. That Social Gloves or Simply Greatness's production of the event was in chaos and at risk of not airing, that the deal with MGM, the planned venue for the event, dissipated. It seemed that the MGM deal was made by that Paul dude, so I'm not surprised that that dissipated. And that dissipated with less than 3 months to go to the event. Simply Greatness was scrambling for an alternative venue, but did not have the resources to successfully cement a new venue deal. Yeah, in the middle of a pandemic. With the event at risk, defendants faced a financial catastrophe. Prior to the engagement, Simply Greatness and its attorneys negotiated injudicious agreements with some of the fighters. Yeah. Why did you promise them so much money? It doesn't make any sense to me. Were you just making up numbers? Does money not have value anymore, is what they're saying. The financial compensation promised to some of the fighters was senseless, but beyond that, the imprudence was compounded by the pay or play provision. LiveX is not privy to all the agreements with the fighters, but is informed and believes that had the event not transpired, defendants, Austin and his company, would have had financial liability of $7 million to two of the fighters and an additional $2 million to one of the event's investors, James Harden. So they're saying, had the event not gone forward, there would have been $9 million of liability signed into these contracts with Simply Greatness Productions and Austin McBroom. To salvage the event, defendants asked plaintiff in the final hours to secure a venue for the event. LiveXLive says this was all going downhill into flames spectacularly, and they begged us to get a venue for the event so the event could go forward. The McBrooms say they moved the event to Miami, and they took a beneficial amount of that contract. Weird. We didn't approve it. That was a side deal. They shouldn't have done that side deal. Love to know your thoughts on that. They say that LiveXLive leveraged its relationship and secured a deal on the behalf of Simply Greatness with the Hard Rock Stadium in Miami. Plaintiffs are informed and believe that Simply Greatness's agreement with the MGM provided that they would pay $750,000 to use the MGM. However, LiveX was able to secure the Hard Rock under a sponsorship deal, and the Hard Rock committed to a confidential guaranteed payment to be paid in advance of the event. In subsequent agreement with LiveX, and again, the McBroom lawsuit against LiveX is saying that they don't have that agreement. They don't know what was promised. They don't know what it was agreed to. This seems to indicate, yeah, but it's better than your $750,000 that you were supposed to pay the MGM. In a subsequent agreement with LiveX, Simply Greatness committed to designating the confidential agreement payment to finance a portion of the production and budget for the event, but for LiveX's engagement, a sizable portion of the production budget would not have been underwritten, and again, the success of the event would have been in jeopardy. That's an awkward paragraph for me. They say that defendants initially planned on partnering with Live Nation to secure talent for the event. Prophetically, Live Nation chose not to contract with Simply Greatness. I don't know why they're bothering with they were going to use Live Nation and then they used us, but it seems to be that they were saying, again, the McBrooms were scrambling to make the event reality. In the McBroom lawsuit, they say, no, we contracted with LiveXLive to sell tickets and do all of that. There was no reason to have Live Nation partner, and Live Nation, in fact, is not mentioned at all. So where the truth is in all of that, I'm curious. They say that defendants, the McBroom and their company, requested LiveX's assistance in securing musical talent and hosts for the event. That LiveX again leveraged their relationships and facilitated introductions to talent who ultimately contracted with Simply Greatness to perform the event. It seems that they have not been paid. Simply Greatness, Austin, and Allen requested that LiveXLive increase its role in the event to produce, present, and broadcast the event. Well, we now know why, because Paul yeeted himself. They say that on good faith, LiveX dedicated millions of dollars in human capital to produce the event and ensure its production success. Yet Ally McBroom, on behalf of Simply Greatness, did not sign the agreement until June 9th, 2021, 3 days before the event. In the McBroom lawsuit, they said, we needed this agreement with them and they didn't get it to us. What Simply Greatness or what LiveXLive is saying, no, we started work on it, but they didn't even bother signing it till 3 days before the event. So they both have very different perspectives on what went down with signing that agreement. The McBrooms represented that the event would generate in excess of 2.2 million pay-per-view sales based upon their social media presence. And in the term sheet represented that they expected at least 5 million pay-per-view tickets to be sold. I think we need to look at the term sheet. We have the term sheet. Let's just go look at the term sheet real quick. Did I already close the tab? Yes. We're going to look at it anyway because I'm so curious. I'm so curious. Let's see what the term sheet says about tickets sold. I'm going to control F myself. Look for million. No. Here, we're going to cruise through this document and see where we can get to the term sheet. Term sheet. That's not the term sheet. Nope. I'm just trying to pull up it's like control F yourself, Emily. What we're not going to do. It's attached as Exhibit B, but can you take me there, please? Can you just make that happen faster? This is not going faster at all. There we go. Term sheet. Let's see what it says. Let's see what it says, shall we? Their platform and tech stack will be enabled. It will provide a 360-degree ecosystem, commission split, production and distribution, settlement. This is LiveXLive paying it out 30 days after, which is at issue in the McBroom suing them suit. Promotional plan, credit, insurance, maintain general liability insurance, the technical audit that will happen after, the audit rights. Simply Greatness is entitled to a detailed accounting 15 days after the event. In the lawsuit, they're saying, we didn't get that. So where is the accounting? Confidentiality. This is all confidential, but it's in the lawsuit now. So there we go. Governing law, state of California, again, which is why the lawsuit is there. Expenses, remedies, equitable, all the things and remedies, representations and warranties. LiveXLive shall use its commercially reasonable best efforts to provide the stream to every user. For the avoidance of doubt, Simply Greatness anticipates but does not intend on limiting selling 5 million streams. It's in there. It's going to be very hard for the McBrooms to say, look, they gave us all these wild numbers and induced us to sell all this when in the agreement that they signed, it says they anticipated selling 5 million streams. Let's get back to LiveXLive suing the McBrooms. Once LiveXLive's marketing team became engaged, it became very apparent that the McBrooms and Simply Greatness were completely out of their element, and the event was destined to dramatically underachieve. Despite the promise to collaborate on the marketing, Austin McBroom rejected these sensible and evidence-based overtures. For example, on one occasion, Austin McBroom would boast, quote, "We don't need to do marketing. We have 600 million impressions." Okay. 600 million impressions got you like 130,000 pay-per-view clicks, pay-per-view purchases. And I said, but conversions are different. And then the next statement, because you get when you see my notes, you get my live thoughts as I'm reading through this. This statement and other statements made by Austin McBroom evidence his naivete as he equated impressions with conversions. The thing is, they call Austin McBroom out saying, "Oh, you arrogant man. You think impressions are conversions?" But then in their fucking press release, they said we had billions of impressions. So come on. You can't shade somebody for something that you've put in your press release too. They talk about the chief marketing officer who has 30 years marketing experience, who told Austin that his social gloves continues with its laissez-faire approach. Get off your ass and market, that you're not selling 1 million tickets, let alone 2.2 million. Austin said, "You're wrong." LiveXLive CMO said, "I'm going on record to tell you that." Well, 130,000 tickets sold is way less than 1 million or 2 million or 5 million. Just put that on the record. Eventually, LiveXLive managed to get Simply Greatness to sit down and do a marketing sidebar on April 30th, 2021. The marketing team met with Alan McBroom, Austin McBroom, and his trainer, Yogi. What? What? His boxing trainer came to the marketing meeting? Is that what we're taking away from this sentence? Is that what we're taking away from this sentence? And Paul. Hi, Paul. The LiveX team presented a marketing strategy and programs report. An 18-page strategy detailed a step-by-step program and chronology in order to achieve 2.2 million in sales. Initially, it was approved. However, once implementation was to begin, defendants backtracked and withdrew support from the strategy. They say Austin McBroom's arrogance was outstanding, as he failed to honor minimal marketing tasks, which Simply Greatness was contractually obligated to perform. What you can't do is just not market it. For example, simple tasks such as ensuring that the fighters deliver social media posts with links to purchase tickets went unfulfilled. If you are running the event, if or Simply Greatness is running the event, you have to make sure that the fighters uphold their marketing end of the event, which means their contracts have to say, you're going to deliver this many posts, you're going to do these things. All of that has to be hammered out and followed up on. Yes, it's a lot, but if you're standing to make a lot of money, you have to do some work. The CMO watched the data closely and advised Austin and Allen. For example, Stone would report to them the number of visits to the landing page. She cost in Austin's approach, or lack of an approach, was a failure, saying the math is not working. The math is not working is corporate for you have to fucking do something or this will fail. The math is not working here. LiveX's marketing strategy was vindicated, even if on a limited basis, when it dedicated $300,000 to marketing in accord with the programs detailed in its report. This marketing generated $1.6 million in ticket sales, a 400% return on investment. Had defendants implemented the strategy, a strategy which defendants had represented at the time of contracting they would implement, the event would have been financially successful with adequate returns to pay the fighters. It's been widely speculated that the fighters haven't been paid. Some of the fighters have said they haven't been paid, and this lawsuit also confirms that most of the fighters haven't been paid. And I say most, we'll get to that in a minute. Defendants received regular reports from Tableau on the progress of sales. These reports were exactly the same reports on the same cadence sent to Stone and LiveX executives. Immediately following the event, defendants received notice that the actual sales were approximately 136,000. It's not very close to 5 million, which is interesting because in the McBroom versus LiveX suit, they're saying, hey, you never gave us the numbers. In this suit, they're saying you got it directly from the people the same we did. Defendants, in an effort to sustain their social reputation, developed an untruthful narrative. Defendants published statements immediately following the event that LiveXLive was lying about actual sales number, was cheating defendants, diverted pay-per-view sales to an undisclosed pay-per-view platform, and diverted sales from Simply Greatness Productions. Defendants reported to the fighters and talent that based on the numbers reported by plaintiffs, the event underperformed and that Simply Greatness would need to restructure its contracts with fighters, talent, and hosts. To lend credence to his false narrative against plaintiffs, defendants announced two actions. One, this is what the McBroom said. that Simply Greatness retained the services of a high-profile consulting company, FTI, to audit the practices of plaintiffs. And 2, that Simply Greatness was sponsoring an illegal sweepstakes designed to collect receipts of pay-per-view purchases. What? The purpose of the sweepstakes was transparent, to secure evidence that plaintiffs had lied and cheated defendants from pay-per-view sales, and that plaintiffs' statements were false. The auditor that Simply Greatness retained, FTI, performed an extensive audits of plaintiffs' protocols. LiveXLive and its employees provided full cooperation. They're saying that FTI orally reported to LiveXLive at plaintiff's request, after a long period of silence, that they had determined that LiveXLive accurately reported pay-per-view sales. In the aftermath of defendants, the McBrooms, defamatory statements causing damage to plaintiffs, LiveX asked FTI when it would be issuing a written report. FTI indicated to LiveXLive that defendants instructed them not to issue a written report. Defendants have not publicly announced the results of the audit, nor have they withdrawn their defamatory statements. As proximate cause of defendants' defamatory statements, the value of LiveXLive shares has drastically fallen by more than 20%, causing nearly $100 million in damages. Following FTI's cleared report on LiveXLive's business practices, plaintiffs attempted to determine the waterfall of payments. The process was completed by various transgressions, contractual and tortious, committed by defendants, the McBrooms. They're saying that the McBrooms financially committed to underwrite a budget, but it failed to fully perform. That means they were footing the money. They were going to underwrite it themselves. The defendants committed to implementing a marketing program in collaboration with LiveX, which they didn't do. The event underperformed by more than 2 million transactions, causing more than 6.35 million in damages to LiveX. They say that the PSA, who's PSA? What are we talking about? I don't know what they're talking about. The PSA provided that, quote, in consideration, the agreement, the acronyms. In consideration of LiveXLive's production services, Simply Greatness shall pay LiveXLive all sums arising out of, related to, or incurred with connection of the production of the event. Plaintiffs incurred substantial amount of costs prior to the event. They continue to incur costs related to the event through the date of the filing. Yeah, because they're still dealing with this shit. Defendant's defamatory statement caused damages. And they said, even if there were funds available for distribution, read, there's no money. No money. No money. Even if there were funds available. Remember, Austin McBroom is suing LiveXLive, saying you haven't distributed the funds. LiveXLive is saying, even if there were funds to distribute, even if there were funds available for distribution to Simply Greatness after payment of plaintiffs' costs and damages arising out of the breach of their tortious conduct, funds which LiveX alleges do not exist. I mean, is it an allegation? Like, where's the money, folks? There or it's not. See, it depends. How are they saying the money's not there? Are they saying the money's not there after they get what they're entitled to, or the money's just not there, period? See, it's not clear. The process of distribution was complicated by defendants' incompetence and concealment, and by the professional negligence and malpractice of its counsel. They started dragging the lawyer sometime around page 48. The lawyers who didn't put the heading for the facts and are using 28-line pages are dragging the other lawyers. This is not going to go well if we're already dragging the lawyers. How are we going to resolve all of this? Because we might very well be in a situation where two wrongs don't make a right, where Simply Greatness has done things they shouldn't have done, like not performing on the marketing, and LiveXLive has done things like they shouldn't have done, like selling the NFTs. Everyone might be wrong, and then it's going to have to go either to litigation through trial, where a jury's going to have to parse through, well, they did this to me and they did that to me, or it's going to have to go to some mediator who's going to have to sit there and be like, all of you shut the fuck up. You didn't do this. You didn't do that. You're damaged by this much. You're damaged by this much. You pay them, or all of you walk away. Goodbye. There's no money anywhere for any of you. Fuck off. A mediator wouldn't say that. That was just my annoyance. They say, for example, let's get into the Bryce Hall of it all. Let's get to the Bryce Hall of it all. For example, Simply Greatness entered into an agreement with Bryce Hall Biz LLC. Really? Really? With Bryce Hall Biz LLC for the services of Bryce Hall as a fighter of the event. Simply Greatness and Bryce Hall represented to LiveX that Bryce Hall had priority for payments subordinate to only the financer of the event, James Harden. By the way, it's been reported that James Harden is suing. I haven't seen a lawsuit where James Harden, the basketball player James Harden, is actually suing. I haven't seen it. I keep looking. I don't think James Harden is actually sued yet. Unbeknownst to LiveXLive and Bryce Hall Biz, 2 weeks before it entered into its agreement with Bryce Hall, Simply Greatness entered into a similar agreement with Taylor Holder for the services of Taylor Holder as a fighter. I like that Taylor Holder's LLC is just Taylor Holder LLC. That agreement guaranteed priority to Taylor Holder on terms which appear equivalent to the rights granted to Bryce Hall. Here's why that's problematic. Everyone can't have priority. Priority means one priority. So the subordinate only to the financier means James Harden gets paid first, and then whoever has next priority gets paid next. If there's not enough money from the event to go down the line, then people down the line don't get paid. But that was promised to both Taylor Holder and Bryce Hall, according to the allegations in this lawsuit, which doesn't surprise me because the third lawsuit in this trilogy is Taylor Holder suing Bryce Hall. No, Austin McBroom. It's too many names. Based on Simply Greatness's misrepresentation regarding Bryce Hall Biz's priorities and at the strong and persistent insistence, LiveXLive executed a letter of direction wherein it contracted to make payment to Bryce Hall on a priority basis. What this says to me is that Bryce Hall got paid, but that Bryce Hall and Taylor Holder both had priority terms. And Austin McBroom told LiveXLive that Bryce Hall had priority and he had to be paid. And it looks like by this, he was paid. Those are the allegations in this suit. I don't know if Bryce has addressed it on social media, but it looks like from this, he was paid. But the agreement with Taylor Holder, according to this lawsuit, was signed before the Bryce Hall lawsuit, which means Taylor Holder should have been paid first, not Bryce Hall. So if Bryce Hall was paid and Taylor Holder wasn't, that's not going to be hard to lay all the contracts next to each other and go, I had priority payment terms and it was signed first. What a fucking mess. Meanwhile, LiveX is facing conflicting claims for payments from other fighters, investors, and related individuals, and has been threatened with liability from multiple parties should it not acquiesce to these threats. The risk of liability was created by Simply Greatness's incompetence at best or its deceptive practices at worst. I'm not surprised when Austin McBroom went on social media and was like, LiveXLive is holding all the money. I'm not surprised that everyone who didn't get paid was like, oh, really? Hey, LiveXLive, where the fuck's my coin? Pay me. I'm not surprised at all. I'm not surprised at all. They're saying that because of the McBroom and company's failure to honor its contractual obligations and their pre-contractual representations to appropriately market the event, Social Gloves dramatically underperformed. Thus, even if LiveXLive went uncompensated, even if LiveXLive wasn't paid for the substantial investment to ensure the occurrence of the event itself and the success of the event, there would be insufficient funds to pay the talent and the hosts. Even if LiveXLive wasn't paid at all, there still isn't enough money because of what was spent. Where's the money? Gone. At defendant's plea, LiveX leveraged its relationship to facilitate. That's got to be a typo. Leverage its relationship to facilitate the contraction between Simply Greatness and the talents and host. However, because of the underperformance and the promises of priority payments to James Harden and Bryce Hall Biz and Holder, and perhaps others who have not yet been revealed, talents and hosts will not be compensated unless dramatic restructuring occurs. LiveXLive has pleaded with Simply Greatness and the McBrooms for authorization to pay the talent and host, but defendants are recalcitrant. That's where we're throwing it in. That's where we're throwing the SAT words into this lawsuit. Defendants are recalcitrant. Defendants want you to give them the money. They're arguing in their lawsuit. The McBrooms are arguing, give the money to Simply Greatness and we will pay the monies out. And LiveXLive is like, I don't want to get sued. We're not giving you any money. Plaintiff's CEO and president have met with Austin McBroom and offered to forgo a substantial sum of money, to which plaintiffs claim entitlement if defendants will work with plaintiffs on restructuring the deals to get the Townsend host paid. Defendants are unapologetic, if not oblivious, to the risk of liability their conduct has conferred upon plaintiffs. Plaintiffs have endeavored to facilitate payments to James Harden, simply asking for a letter of direction from Simply Greatness and assurances that Harden is, in fact, legally in first position. Simply Greatness has not cooperated, to the frustration of Harden's counsel and plaintiffs. No shit. Defendants continue to insist the revenues be turned over. Yeah, they filed a lawsuit about it. However, Simply Greatness has continuously threatened bankruptcy. Some fighters and other creditors have urged plaintiffs, including in writing, to hold the funds in trust out of concern that if the funds are given to defendants, they would abscond and leave the creditors empty-handed. However, the terms of the agreement say turn it over. So that's why they're being sued. These lawsuits, now you're seeing why I'm like, these have to all be under one umbrella in one court. These lawsuits go together. They're all the same course of events. I don't know why it wasn't filed as a counterclaim, maybe because they still want to argue some of the procedural stuff with the other lawsuit, but these all need to go together. This is a mess. This is not going to be easily resolved in trial because there's no money left. So everybody spending this money on litigation isn't going to help. This should all go to mediation, determine what money's left, and then swoop in all of the other creditors. But this trilogy of lawsuits feels like it's destined for bankruptcy court. Like all of this feels like it's destined for bankruptcy court. But you need more than just a few. If all the fighters got together as creditors, you need at least 3 in California to do an involuntary bankruptcy like they did with Girardi. So if you have LiveXLive and you have Taylor Holder and you have James Harden, you've got at least 3. I'm just saying, it feels like at some point they are going to want to either force an involuntary bankruptcy. But the thing is, I don't know if Simply Greatness is funded enough to sell off anything. Like you're seeing Tom Girardi's law firm being liquidated. They're selling everything from the art on the walls, the paintings of him, memorabilia, photos of him in Erica Girardi, and all of the awards he ever won that seemed to be meaningless. But they're selling literally everything from the chairs to the hangings on the walls. Simply Greatness is an LLC that's operating in their names that I would not be surprised to find out if it wasn't funded because the McBrooms are funding it and they didn't like put millions of dollars into this LLC to fund it, so that this LLC on the books has 0 money and is operating kind of as a pass-through entity. So even if they pulled it into bankruptcy, it would end up going after the personal assets of the McBrooms. Oh, it's so much. All right. First cause of action, defamation. Defendants made defamatory statements with actual malice, knowing their falsity, or with reckless disregard for their falsities. The statements made above are the statements that we covered above, that it caused damage. They actually can say, hey, it caused damage. These things were said and our stock prices dropped. Unfair competition, that by engaging in the defamation, somehow they are, Simply Greatness is now competing with LiveXLive to produce these events, and the defamation is unfair competition because they're in the same space. That's also a cause of action in the H3 defamation case with Triller. Though I think Simply Greatness and LiveXLive are better situated as competitors than Triller and the H3 podcast and Ethan Klein are. I think this is more situated. They say that defendants have violated and continue to violate the law and the unfair business practices by engaging in retaliatory, harassing, and malicious defamatory conduct, gaining unfair advantage because of that, et cetera, et cetera. Third cause of action, breach of contract against Simply Greatness. Hey, you didn't uphold your end of the term sheet, fuckers. You should have marketed the event as we set forth. Intentional misrepresentation. Plaintiffs committed substantial resources to producing the event with regard to transactional fees and service fees generated from each ticket sale predicated on the $5 million sales. Defendants intended to induce plaintiffs to rely on their misrepresentations. Mom, they said this to me, so I did this. Both of them are arguing the same, which is why these should be cross complaints. Well, they said this to me. Well, they said this to me. Well, I thought it was going to be this many. Well, it was their projections. Mess. Intentional interference with prospective economic relations, that the talents and host had a relationship that would have been beneficial to plaintiffs down the line. Those have been burnt because they're not being paid. And then here's the thing. Not only was there not a header for the facts, the sixth cause of action just isn't there. They amended the complaint and did not add the sixth cause of action to the complaint. Look at this. We're going to go up to the top. We're scrolling, people. We're scrolling. They added a sixth cause of action for injunctive relief. They want the court to enjoin Austin McBroom, Simply Greatness, Alec McBroom, and Catherine McBroom for doing something. They want them to stop them doing something. And we've seen injunctive relief in the Haley Page lawsuits. We've seen injunctive relief in the Nike Satan shoes. We've seen injunctive relief in Tati Westbrook and Clark Swanson. We've seen lots of examples of injunctive relief. You know what we've never seen? We've never seen a lawsuit where they say there's injunctive relief and then don't plead it. This is new, folks. This one's new. What injunctive relief? Where is it? Show me the injunctive relief. Because as we get under the fifth cause of action, where one would typically find the sixth cause of action, it's just missing. Who didn't add it? Who didn't proof this? What poor associate attorney didn't do this? What paralegal didn't get a chance? Because paralegals didn't make this mistake, I don't think. Who didn't proof it? Why? Not only do your pages not line up because it's on 28 line paper instead of 26 line paper, but where's the sixth cause of action? You don't get to plead the sixth. That's not how it works. You can't even plead the fifth. You have to allege it. It's $100 million lawsuit that you're super proud of, LiveXLive. Where's your sixth cause of action? We all would like to see it. I would love the 12B6 motion on this. This is a 12B6. Your Honor, they've failed to adequately plead their sixth cause of action because it's not fucking there. Good Lord. Prayer for relief. Damages, including general, compensatory, special damages in an amount to be determined at trial, but no less than $100 million. We will settle for nothing less. From where? From where are you going to get that $100 million? Punitive damages, the punishment ones, an order enjoining plaintiffs from engaging in further retaliatory conduct. Yeah. An injunction requiring defendants to cease engaging in unfair competition. Too bad you didn't plead for an injunction. So you can pray for the relief all you want. What you didn't do is add a sixth cause of action. So negative, ghostwriter. That pattern is full. Costs, attorney's fees. Why isn't it signed? Like, Jeff. Okay. It's all right, sure. The judge is going to be thrilled when he sees y'all in November that's not signed. So next court date on that is going to be December 8th. December 8th is the next court date. There's one more, but we're at 2 hours. So here we're going to peruse real quick. The mods are like, "Oh good. Go to the bathroom if you need to." We're going to peruse real quick. I didn't know when Coffee and Cursey Words started being a more than 2 hour live stream, but here we are. Taylor Holder LLC, and Nathan Scott Wyatt are suing Austin McBroom, Simply Greatness, and Alan McBroom over breach of contract, breach of implied covenant of good faith and fair dealing, intentional misrepresentation, negligent misrepresentation, intentional interference with contractual relations, and civil conspiracy. There's a conspiracy. Austin McBroom and his family gained notoriety in 2017. Oh, I should have started with this one. This is a first look for me. I hadn't had a chance to read this one yet because there are so many things. This one would have told us who the McBrooms are. We should have done this one first. I forgot to swoop. Apologies. Let's swoop. Ready? Are we ready? Taylor Holder, his company, and Nathaniel Scott Wyatt sue Austin McBroom, Simply Greatness Productions, and Alan McBroom over the YouTubers versus TikTokers boxing event. This was filed on August 2nd, 2021, and confirmed on social media. But this has the best recitation of who Austin McBroom is so far, and this is a good first look. So this is a live lawyer reacts. Let's see what Taylor Holder's lawyers has to say. Austin McBroom and his family gained notoriety in 2017 on YouTube, vlogging their day-to-day lives on their own Ace Family channel. As scandals involving McBroom surfaced, there were many allegations of cheating. Holy shit! The lawsuits are allegation and shade, friends. This is going to not just be allegations and shade, but this is going to bring in all of the internet's allegations and shade as well. We're just bringing it all in. Hard R assault, sexist and racist tweets, a staged burglary, fraudulent charity events, a fan club with false promises of merchandise. Wow. Okay. You should go put that shit all out there on the street. The McBroom's number of followers grew. As scandals involving the McBroom surfaced, the McBroom's numbers of followers grew. And as the number of followers grew, the McBroom financial fortune swelled, sustaining for now their insatiable appetite for extravagance. No, they told us in their lawsuit that it's LiveXLive who wanted the Gatsby-esque event, not them. It wasn't them. Where were we? Oh, insatiable appetite for extravagance. I want that to be the name of someone's memoir. Monuments to the gods of speculation and insatiable appetite for extravagance. I want that to be the name of my memoir. Damn it. I need to step up my game with my insatiable appetite for extravagance. This is going to win as one of my favorites. This is one of my favorites. I love this. Insatiable appetite for extravagance. Playing the side stage at Coachella. Okay, let's keep going. A $10 million house, an orange Lamborghini, and a Rolls Royce. I mean, compared to other YouTubers, I feel like this is mild. The house, by the way, there are lots of reports that the house is being foreclosed on. Those are allegations. I don't know if that's true, but we will see. Oh, the shade of it all. The shade of it all. Again, lawsuits are allegations and shade. This one's going to bring up everything ever said and be like, bleh, you suck. Because this complaint is really, hey, you suck. And you're not going to pay for us. So we're going to just put this shit all out on the street. Capitalizing on the introduction of boxing exhibitions involving social media celebrities, first introduced 3 years ago, McBroom conceived of Social Gloves, Battle of the Platforms, the event. Like previous exhibitions, this event would feature amateur boxing matches. However, Social Gloves' event, or the Social Gloves event, Jesus. I am not perfect. I am ADHD. I am dyslexic. My grammar is not the best. But this is hard. Social Gloves event was designed to drive more followers to his nascent Social Gloves empire. This event would pit YouTubers against TikTokers. The key from McBroom was to entice event participants with a large number. I'm dying. With large number of online followers. I'm going to try to just not fix it while I'm reading it. I'm going to try to just read it as it is written. Twisted Puppet says that was Keemstar that thought of the idea of YouTubers versus TikTokers. McBroom didn't come up with that. Well, okay, according to Taylor Holder's lawsuit, they think Austin McBroom did. Maybe Austin McBroom thinks that he did. Ashley Vincent, again, I say, what the fuck is subject verb agreement and why do we need it? This is so hard for me to read. In turn, these followers would be attracted to an event which gave top billing to Austin McBroom. Daddy, I want a boxing event. I want to be the star, the biggest star of my own boxing event. I want it now, Daddy. In other words, Austin McBroom sought to grow his empire on the shoulders of other internet personalities. First, to accomplish his scheme, McBroom needed credibility. Oh, good. Let's lay it out. He engaged Paul as the executive producer, a veteran in the entertainment world specializing in new media, digital, social platforms. McBroom supplemented his team with 2 entertainment law firms to assist with the organization of the event. To assist with organizing the event and negotiating the deals with the talent, Jason Zivin of Sanders Roberts and James. Is there a comma? Wait. Or is it a law firm name? Jason Zivins of Sanders Roberts and James Samatro of Pryor Cushman, the attorneys. As the social media world can be very competitive, McBroom's ability to attract other social media stars would be contingent on his hiding his ownership of the event from the other social media influencers whose involvement he pursued. The ruse began with the McBrooms incorporating a single-purpose LLC, Simply Greatness Productions. McBroom and Zivin chose Delaware as the state of incorporation, where McBroom could take advantage of the state's anonymity protocols. I don't know if this is true, but like the impetus behind it, but in Delaware, you can't always easily get to who is behind the corporation. So you don't always know. You can't just go look it up and easily see who is behind and who incorporated the corporation. So there are anonymity protocols in Delaware. When the other social media stars began to ask questions about the ownership of Simply Greatness, Austin McBroom and the Simply Greatness attorneys had a secondary scheme which they employed. Alan McBroom and Zivin suggested that the ownership of the LLC be transferred to Paul on the day of a significant contract signing. Well, there's way more tea in this lawsuit. Alan McBroom further suggested that following the execution of the agreement, ownership would then be returned to Austin McBroom. No. Nope. That's not a good idea. Negative, ghostwriter. Nope. Paul was stunned by Alan McBroom and Zivin's devious plotting. Oh, maybe that's why Paul yeeted. Is this why Paul yeeted himself? See, this is why we need the trilogy, because the trilogy is giving us life. Is this why Paul bounced? Why Paul was like, the fuck with y'all? What we're not going to do is risk my reputation. Is this why Paul bounced? Though the grammar is killing me, the tea is scalding. In other instances, McBroom and the attorneys would simply forego Simply Greatness's executing the talent agreements. What? Well, then who was executing the talent agreements? Here's the thing, though. This would make sense in context as to why Paul just seemingly bounced out of this and why there's that shade in the other lawsuit. The LiveXLive lawsuit throws the lawyers under the bus. So is this why the lawyers are getting thrown under the bus? Is it Taylor Holder's lawsuit that's just like, let me fill in the details for y'all? This is why the lawyers are getting thrown under the bus. Okay. Alan McBroom further suggested that following the execution of the agreement, ownership would be returned. Next, it was important to entice. I like that they're like, let's take it step by step. Who's behind the mask, Scoob? Next, it was important to entice an investor to underwrite the cost of producing the event. This McBroom would accomplish with promises of large-scale event and a large payday. To do this, Austin packaged his own marketing deck entitled The Largest PvP Event in History. Again, making it poorly taken that in Austin's own lawsuit, he says it was LiveXLive that induced him to fund an extravagant event. No. Oh no. Taylor Holder came in with let me show you what the fuck you said. Largest pay-per-view event in history, McBroom versus Hall, YouTube versus TikTok, spring 2021, YouTube, TikTok, and then it's got all their social media stats on all their follower numbers. Look how important we are with our large follower numbers. We so famous. Oh, significant others, social followers, Addison Rae. And then they've got their boyfriends. Wait a second, the sexism of it all. Y'all. And look at the little ladies and who they belong to and their social media followings. Oh, fuck this. Fuck all of this. Addison Rae, Grace Hall, Catherine McBroom, with Austin McBroom, Hannah Stocking. I don't know who that dude is. SJ Blue. I don't know who that dude is. Dixie D'Amelio. Who? And Charlie Jordan. Who is Dixie D'Amelio tied to in all of this? Somebody let me know, because this is not easy to read down here. I need this. I need a better form of this, because the tea of it all, I need a link. I need a link. By the numbers, combined reach, YouTube plus TikTok, 393 million. Projected PvP streams, 10 million? Based on a 2.5% purchase rate. This does not account for the fact that there's going to be an overlap in followers. Like, this does not account at all for the fact that some of these followers will overlap. What? Projected gross revenue, $500 million. Let's just say numbers, okay? We're just going to say numbers. We're going to stream 10 million. We're going to sell 10 million streams. $500 million. Let's just say numbers. No accounting for the fact that some of the, not accounting for the fact that from any of these influencers, some of the people that follow them on one platform are going to overlap and follow them on another platform. And then some of the people who follow, Taylor Holder are also going to follow whoever Noah Beck is and Bryce Hall. There's going to be overlap. There's going to be overlap. Okay. Let's keep going. In another version of his marketing deck, McBroom showed Kevin Hart, not Kevin Hart. Why does it always come back to Kevin Hart? Why is Kevin Hart getting dragged into literally everything? Not the Kevin Hart of it all. I did not put Kevin Hart on the bingo card. Because I did not have Kevin Hart on the bingo card at all. Put him on the bingo card. In another version of the marketing deck, McBroom showed Kevin Hart as the host for Social Gloves. Is he just taking a page from Triller? He's just copying Triller. Look, Triller has Kevin Hart. We will have Kevin Hart too. McBroom showed Kevin Hart as the host for Social Gloves, despite McBroom's never approaching Hart directly for the project. McBroom was informed that Hart would be out of the country during the event. Event details, combined reach, YouTube, TikTok, Instagram, total reach, 702 million people. Venue, American Airlines Arena, Miami. What? Estimated pay-per-view purchases, 5 million. Projected gross revenue, 200 million. Host Kevin Hart. National anthem, James Charles. I should have started with this one. It was filed last, but it's first in my heart. I can't. Wait, did the projected, how did the projected, this is projected gross revenue. Wait, what happened? Projected pay-per-view streams, 10 million. Projected gross revenue, 500,000. I wish these were dated. Because they changed the projected streams went down. Tickets, pre-sale, $29. Second pre-sale, $39. On sale, $50. Contact info. Poor Paul. Oh my God, I'm dying. I am dying. I'm ready for Kevin Hart to sue everybody and be like, stop using my likeness to sell your shit, YouTubers, social mediaers, TikTokers, all of you. Stop using me to sell your shit. Stop it. What you're not going to do. I'm crying. I'm sorry. I can't. Oh my goodness. Literally cry. Okay. Okay. Oh my God, my eyes watering. I'm dying. The grammar's killing me, but the shade is fantastic. All right. McBroom developed a dazzling mathematical formula based upon social media followers. The equation yielded promises of combined reach of 393 million followers and projected gross revenue of $500,000. McBroom shopped the event to potential investors. He landed James Harden and Little Baby as co-investors. The investors advanced $2 million with the promise of being in first priority position to recoup their hard money and an additional 10% of adjusted gross revenue. That could have been so better. Their investment. McBroom would use the same deck to entice YouTubers and TikTokers with a marketing deck that demonstrated astronomical revenues. If McBroom was going to engage these social media influencers, he would have to tempt them with their own big paydays. In a span of a month. Okay. McBroom, behind the veil of SGP, and the SGP attorneys offered colossal payouts to the social media personalities referred to as talent for the talent's promises of entering into the ring for 3 to 6 rounds. SGP agreed to pay the talent as much as $5 million. In the case of Nathaniel Wyatt, SGP offered $500,000. For Taylor Holder, the compensation was $2 million. I'm dying. Relatively small initial payments were paid prior to the event. The majority of it, contingent compensation, would be paid after the event. In addition, Simply Greatness gave the talent the ability to share in the massive projected profits. Thus, Holder was guaranteed $2 million against 2% of adjusted gross revenue. For many of the talent, they were bedazzled. They were bedazzled? They were bedazzled? That's what we're choosing? What about dazzled? What about overwhelmed? What about money? Okay. They were bedazzled by the marketing deck and accepted the promise of a large payday. For the savvier talent who were concerned about getting paid, McBroom had to field requests for first position and first priority. If you take anything away from this, anything at all, grammar is important, kids, and first priority, first position matters in a contract. Unless everything goes bankrupt, but it matters. The problem for McBroom was there could only be one first priority. True that. Didn't we just say that? But as long as each talent making the request did not know what the other talent was promised, McBroom could acquiesce to the multiple requests for first position. So under the cloak of confidentiality provisions in each agreement, Simply Greatness agreed to first priority provisions for 3 fighters, its executive producer, and its primary investor. I wonder how they know that. Did they all chat? I wonder how they know. I want to know how they know. Did they all chat? And again, in anticipation of litigation, them all chatting about provisions that might have been under a non-disclosure doesn't really get them into trouble with the non-disclosure if they're trying to go real-world litigation with it. The 1-month spending spree in order to lock up the talent with exorbitant contracts caused McBroom's business manager, Mark Goodman, to remark to McBroom, "You are spending like a drunken sailor." I want to know how we know that happened. But the McBrooms turned around and sued LiveX, saying that it was their inducement. LiveX is going to turn around and be like, "Hey, Mark, did you really tell him that?" Because LiveX is going to turn around and use that in their defense. McBroom and Simply Greatness attempted to land Live Nation to stream the event. Also, I've not said it the entire stream, over 2 hours. Don't forget to like and subscribe and things, like, go ahead and like the stream. I haven't asked for the YouTubey things. My bad. Do the YouTubey things. We just have to get to the documents in the shade, to the allegations in the shade. So they wanted to land Live Nation to stream the event. Live Nation opted to forgo participating in the event. Paul managed to land LiveXLive with less than 3 months before the event. So LiveXLive didn't even come on until 3 months before the event because Live Nation didn't do it and they were counting on Live Nation. Interesting. This gives a whole lot more context. I appreciate it. Grammar aside, I appreciate the context. As LiveXLive revenues was transaction-based, LiveXLive agreed to act as the live stream partner with the provisions. This is all speculative and conclusory because this isn't LiveXLive's lawsuit, but after knowing what LiveXLive put in their lawsuit, we know. LiveXLive developed an extensive marketing plan. I mean, somebody talked to somebody with the goal of achieving $2.5 million in sales, though they could have just read that in the lawsuit too. The plan, however, required an investment of marketing dollars. McBroom refused to heed the recommendation. How do you know? Is this all based on LiveX's lawsuit? Maybe. McBroom refused to heed the recommendation of LiveXLive's marketing team. McBroom insisted it was sufficient to rely on the power of social media. In fact, Simply Greatness agreements with the talent all included the following provision. Talent shall promote their participation in the event across talent's social media channels. That's not enough. It has to say what and when and how and what days, all the things. It has to say all the things. It can't just say, you're going to promote it. Well, does that mean one post? Does that mean a story? Does that mean one tweet? What does that mean? That is, Simply Greatness required the talent to promote an event which gave Austin McBroom top billing. McBroom was warned by 2 experts that SGP's promotional strategy will not drive ticket purchases. This is all speculative and hearsay. Like, okay. McBroom pointed to all the impressions. This is straight from that other lawsuit that the event was generating. Stone admonished that impressions do not equal conversions, but McBroom knew that. His goal was to elevate the number of followers, the element which brought him and his family wealth during the last. So they're saying that Austin's entire goal was to pad his own numbers and his own fame, is what they're alleging. I don't know how they know about the business manager. I'm so curious. McBroom's business manager, Goodman, also sounded the alarm. He advised McBroom to cancel the event because there was little chance that based on the numbers at that point, the event could generate sufficient sales to cover the talent contracts. On or about April 12th, Paul left a message. How do you know? On or about April 12th, Paul left a message. The McBrooms later acknowledged by Alan McBroom in a return text, quote, "Hey, bro, you left us a voicemail over the weekend on how concerned you are with us not communicating and that we're making deals with artists and promising all this money we don't have and that we're pulling a Ponzi scheme." What? How do you know this? How, unless their lawyers are talking to Paul and have sworn declarations, how are they affirming this in a filing? It doesn't say upon information and belief. They're alleging this is true in this filing. Again, filings are allegations, but it doesn't say on information and belief. They're saying, we know this. Do you have the text? And if you have the text, what is it attached? Because none of these seem attached as exhibits. There's a lot of conclusory statements in this one. Neither Alan McBroom nor Austin McBroom responded substantively to Paul's indictment. Well, how do you know? McBroom ran through Goodman's stop sign. He had another plan. That's all conclusion. How do you know what the fuck McBroom was thinking? How do you know? You can't know what he's thinking. You can't know what he's thinking. You can't put in a lawsuit that you knew what was in Austin McBroom's head. None of us know what's in Austin McBroom's head. The event did, in fact, proceed. Plaintiffs and the remaining talent lived up to their end of the bargain. In the months prior to the event, they trained, they promoted the event, and on June 12th, they came to the event and fought their fights. When the evening concluded, it was announced that the pay-per-view audience was 136,000, no shit, a far cry from the numbers McBroom had touted in his deck, yet the numbers were consistent with the projections of Miss Stone. McBroom then activated the final two components of his plan. How do you know? First, he deflected the blame to LiveX for lying about the numbers. Second, they retained the legal services of the high-powered bankruptcy attorney, Richard Polsky of Polsky, Stang, Zeal, and Jones. How do you know? This is how we know. On June 21st, 2021, he sent a letter to the talent advising. In light of the apparent underperformance of the event, our firm has been retained to represent Simply Greatness in connection with either a workout of claims of all its creditors, or if a workout is not feasible, a likely bankruptcy filing. Follow the money, there isn't any. While the lawyer was preparing this notification to the talent of the impending cram down or a bankruptcy, McBroom on June 19th, 2021 dropped a new video in which the Ace family touted the success of Social Gloves, and at the end of the video, McBroom announced a part 2 of the Battle of the Platforms boxing event. What? Social Gloves Battle of the Platforms coming soon. What day was this on? June 19th? Okay. The majority of the talent had not been paid for their efforts. This event was a success for one entity and for one entity and entity only, the McBroom family. The McBroom plan, again, they can't know that. They could say the McBroom plan seemed. The McBroom plan was to build a social media boxing promotion enterprise that would be leveraged on the backs and efforts of his peers and fellow social media stars. The plan was carried out on the false promises of financial gain to investors and talent. Though the McBrooms say that that's exactly what LiveXLive did, and that they are building their next event on this event's success or lack of success. Having successfully duped the fighters in the Battle of the Platform Part 1, he is now preparing to duplicate his success. You know what? Success should be in quotes in Part 2. Parties: Taylor Holder LLC, Taylor Holder the individual, Nate Wyatt. However, I don't know if the plaintiffs are properly joined because the contract with Nate Wyatt and the contract with Taylor Holder are going to be different. Again, I know that plaintiffs want to be separated or not be separated because it's expensive to file 2 lawsuits. I don't know if these plaintiffs will be properly joined at the end of the day. Just saying. This is does 1 through 100. That's a lot of does, but okay. Oh God, why is there so much more? Factual allegations. Social Gloves was an amateur boxing event featuring YouTubers and TikTokers. The main event was between YouTuber Austin McBroom and TikToker Bryce Hall. The undercard had a bunch of other people on it. The event was organized by Simply Greatness and its principal members, Austin McBroom, Alan McBroom, with the assistance of lawyers. Paul was the executive producer. In March, Austin and Alan and Paul and lawyers approached Taylor Holder to participate. Holder is an American social media personality, singer, and actor best known for his videos on TikTok. If you're just on TikTok, are you an actor? Holder is one of the platform's most followed members with more than 15 million followers, except the TikToker that I love, whose name I'm going to totally blank on, just hit 100 million. He's the French guy who makes the like common sense faces. I love. But okay. Most follow with 50 million. Look, man, we're sitting over here at 100,000, 148,000. I'm not going to throw stones at anybody's 15 million. I'm just saying. Some of them have 100 million. I'm actually glad that Taylor Holder brought this lawsuit because it does give us some context. Grammar problems aside, we do have some context. During the same period, Austin, Allen, and everybody approached Wyatt to participate in the event. These should be separate plaintiffs. Wyatt is a musician best known for his video creations on TikTok, which has earned him more than 5 million followers. I mean, I'm sure it was like, hey, you can join with us, but that's like you don't get to find your line buddy for a lawsuit. That's not how it works. The plaintiffs have to be similarly situated, and these are going to be separate contracts with separate payout provisions. I just don't see that working. But if there's no money, it might just at least induce them to settle with the two because they filed it together instead of litigating. Because now the McBrooms are being in a lot of lawsuits is way more expensive than being in just one lawsuit. And I can understand for everyone suing Austin McBroom that it's like, look, you're fighting a multi-front war here. You have to fight the lawsuit. His wife's involved in a lawsuit with regard to skincare. We'll get into another day. So the wife has a skincare lawsuit. The wife is now in this $100 million lawsuit with regard to LiveXLive. So they have to pay lawyers to deal with the LiveXLive lawsuit where they're being sued. They have to pay lawyers to deal with the lawsuit where they're suing LiveXLive. And now they have to deal with the lawsuit where they're being sued here. So for anyone else who wants to sue them, it's like, look, they've already fighting a forefront battle. We might as well just jump in. Eventually, they're not going to be able to defend on all fronts. But at what cost? Like, at what cost? You win the war and there's no money left because all the money's gone to the lawyers. And you get a judge being like, yeah, you're right. Can't get blood from a rock. Good luck. Have fun. You can try to garnish their wages down the road. Have fun with that. You're going to spend a fuck ton more money trying to chase down any money that you might be entitled to. But okay, go off. It's more expensive to be in multiple lawsuits, obviously, than to just be in one. They're saying Austin McBroom represented to each plaintiff. We will have 5 million pay-per-view buyers. It's going to be the biggest event. In order to get to the lofty number, Austin McBroom said, quote, "We are marketing like crazy." Well, that's not what the other lawsuit said. On another occasion, prior to plaintiffs agreeing to participate in the event, Austin McBroom said, "I am going to promote like a motherfucker. Catherine will be promoting on Instagram and Snapchat. We will fully leverage the Ace Family YouTube channel." His whole power as a marketer was his YouTube channel, but he only did one video. Oof. He didn't make a call to action. Double oof. Which is also going to come up in the other lawsuit with regard to LiveXLive, saying that he agreed to market and he did not. Austin represented with the comprehensive promotion of Austin McBroom, Catherine McBroom, and the Ace Family, that the other fighters, the event would sell 10 million pay-per-view subscriptions. The McBrooms induced plaintiffs to participate in an exhibition that would last 3 to 6 rounds and no event longer than 6 rounds. Did they tell them? Okay, good. First cause of action, breach of contract by Taylor Holder against SGP only. You didn't pay. You were supposed to pay and you didn't pay. Breach of contract by Nathaniel Wyatt. Again, I think these are improperly joined, but okay. March 9th for services, agreed to pay, didn't pay. Third cause of action, breach of implied covenant of good faith and fair dealing. Don't be a dick in your relationships. You're supposed to follow through with the things you do and do them in good faith. You can't just breach your contract. Thank you, Cabby Lame. Yes, thank you. The TikToker who just hit 100 million, who I very much enjoy their content. By virtue of the relationships between plaintiffs had placed trust and confidence in Simply Greatness. Plaintiffs are informed and believe that within a week of their contracting with Simply Greatness, defendants agreed with Bryce Hall Biz LLC that it would have a priority position. That's in the other lawsuit. Now the lawsuits are informing on one another. Fourth cause of action, fraud by Taylor Holder and Taylor Holder LLC against all defendants. Misrepresentation 1, Holder was in a priority position. They can pay Holder an additional $200,000. They concealed from Holder that they had extended priority provisions to Wyatt and Bryce Hall Biz. So it sounds like the other plaintiff here also had a priority position. Again, a reason these plaintiffs shouldn't be joined, but that's the nitty-gritty legal stuff of it all. Misrepresentation number 4, defendants misrepresented that Paul was the single owner of Simply Greatness and concealed that Austin was the sole member of the LLC. On March 8th, defendants in each of them concealed from Holder and Holder LLC that Austin McBroom was the owner. That's interesting. The truth is that Paul is not now, nor has ever been, a member of Simply Greatness. Rather, Simply Greatness is owned by Austin McBroom. Alan McBroom and the attorneys for Simply Greatness devised a fraudulent scheme to hide from the talent Austin McBroom's ownership. Yeah, that's not going to go well. Misrepresentation is that defendants misrepresented that Simply Greatness would extensively market the event. That's in the other lawsuit too. Defendants misrepresented the weight class of Holder's opponent. Okay. On March 8th, 2021, they misrepresented to Holder that he would be matched up with a fighter in his weight class. When the original fighter who was slated to fight Holder withdrew, they replaced him with Gibb. On June 21st, defendants in each of them misrepresented that Gibb was only one weight class above Holder's weight class. Okay. I lost because you misrepresented it. But also, that's shitty to do to somebody if you're like, no, you're fighting someone in your weight class. And then it's like, oh, just kidding. You're just going to fight somebody else. And it doesn't matter. Just be fine with it. They misrepresented that the Florida Athletic Commission approved the event and that no headgear was required. Oh, interesting. Defendants in each of them represented that the Florida Athletic Commission had approved the amateur boxing exhibition. Further, defendants represented that the Florida Athletic Commission did not require fighters to fight with headgear. Defendants intended to induce Holder to rely on their misrepresentations. Austin McBroom and Alan McBroom recruited into the circle of conspiracy heavy-hitting attorneys, one of California's top 20 boutique law firms, to lend an air of legitimacy to the misrepresentations. As a proximate result of the fraudulent conduct, defendants allege that he was induced into the agreement. Plaintiff was induced to only take $85,000 as an initial payment. He was induced to enter the ring with a fighter substantially outweighed him without headgear in violation of Florida's health and safety regulations for amateur boxing. That's a problem too, if that was misrepresented. Fraud, all the above. They misrepresented that Wyatt was in the priority position. They misrepresented that Paul was the single owner. These are all the same allegations as to Nathaniel Scott Wyatt. Again, these should be separate plaintiffs. Basically the same misrepresentation. 6 cause of action, negligent misrepresentation. Yeah, you said you were able to make all these payments and do all these things and you can't. Negligence misrepresentation to the other plaintiff. This is why these should be separate lawsuits. Because you see how many causes of action. It's like Wyatt versus the defendants, Holder versus the defendants. None of these are Wyatt and Holder versus the defendants because they're not similarly situated. So this is not a class. These will be separated, or should be if they don't settle first. Intentional interference with contractual relations from Austin McBroom and Alan McBroom, that they kept others from fulfilling the contracts, that the reason that was done the way it was done was purposeful and intentional. This should have been bounced down to the next line, but that's just picky formatting stuff. 9th cause of action, civil conspiracy. Not a murderous conspiracy, but a civil conspiracy. From March throughout June 2021, defendants and other non-parties, and each of them knowingly and willfully conspired and agreed among themselves to fraudulently induce plaintiffs to participate in a boxing fight in order to secure and engage Holder and Wyatt. Defendants conspired to conceal the ownership of Simply Greatness, offer hollow promise of priority, withhold adequate event marketing, misrepresent the engagement with the Florida Athletic Commission. I mean, I don't know how we're going to know everybody agreed, but that's going to be interesting. That's going to be interesting. Prayer for relief, damages at trial, punitive and exemplary damages, prejudgment interest, legal fees, signed by lawyer. I think it will be interesting to see if they go forward with litigating this, or if they tell the court, hey, we'll be back. We're going to go try to negotiate this. It doesn't seem like there's going to be money there to fix this. It's just going to be, this is a mess. I wonder and speculate that this might just end up in bankruptcy court. It doesn't seem that there's enough money to cover all of this. And the more lawsuits there are, it would make more sense to pull all of these creditors under a bankruptcy and then be like, okay, this is what money there is, and this is what liabilities there are, and resolve it all under the bankruptcy court. I think that this is probably destined to head towards bankruptcy. If you guys did not like and subscribe, go ahead and do that. I realize we are over 2 hours and 40 minutes in because it was so many lawsuits. A huge thank you to the mods. Give the mods some love. Like and subscribe. I have questions. I'm going to go through questions real quick. We've been on for so long. I'm going to cover court of public opinion on Friday because I have one more poll I want to point up, and we have been talking forever. So, oh my goodness. This is so much stuff. This is so many lawsuits. I didn't realize the Holder suit, because it's the one I hadn't gotten to that we first looked, had a lot of the context. I wonder if the misrepresentations or the alleged misrepresentations in this lawsuit of the owner of Simply Greatness was part of why Paul bounced, because the other lawsuits make it seem like he was just like, oh, I just didn't do my job. And this makes it look like he was significantly uncomfortable with what the fuck that was going on. I'm very curious to see what's going on. It's so much information. Could Austin and Social Gloves be held criminally liable for the alleged fraud? I would need to look at it more, but fraud is a criminal cause of action in most states, including California. So it is always possible. Whether there's an interest there to prosecute it and whether it gets run up the flagpole that way, I don't know if anyone's even made a criminal complaint. But fraud is one of those things. There would need to be quite a large investigation of monies before that. I don't know if they would go that direction with it. But it can happen. So there can be criminal liability for fraud. It's harder with the company, but yes. We'll see if it gets investigated. Question. I've got to make this a little bit bigger so I can read these. Question. If it gets to the point where all the parties are found wrong in the McBroom case, could the parties be fined wasting the court's time and acting like a bunch of siblings trying to plant the blame on each other? Not necessarily, because there are some valid causes of action here. Like, this isn't all just frivolous. There are some real issues here that are going to need to be sorted out by the court. So it doesn't matter that like Social Gloves might have or Simply Greatness might have done this wrong, but LiveXLive might have entered into contracts wrong. There might be wrongs on both sides, but it doesn't mean the other sides weren't wronged. I don't see any of these at this point as frivolous. It'll be interesting to see why they weren't filed as cross complaints. I think these will all end up in the same court. Right now, these are in 3 different courtrooms with 3 different judges, which will be a waste of time. I think that with regard to the Taylor Holder one, the 2 plaintiffs probably shouldn't be joined on the case. I think with regard to the LiveXLive one, where LiveXLive and Paul are both being sued, that they should probably be separated. So this should probably be, where are we at? 3. This should probably be 5 lawsuits, but they should probably all be in the same court because it's all the same witnesses. It's all the same witnesses. It's all the same essentially facts. So these should all be together, not necessarily as one cause of action, but as a consolidated calendar. So, I feel like most people are really enjoying the karma the Ace family is finally getting. I think that's what I'm seeing too on social media. I think that's exactly what I'm seeing too. Question I asked in a super chat, but are you planning to cover the Chris Chan case? Sorry if you answered this. I may have missed it. I've answered it on another stream. Not yet. It is too similar to a few cases I prosecuted that are very, very difficult to go over. So no, I am not at this particular moment planning on covering it. That may change. It's very hard to cover without getting into the weeds on that case. And there's a lot there. So something may change and I might, but at this particular moment, no. Let me make sure I didn't miss any super chats I might have while we were chatting. Question, why did they not file the case in Florida as the event happened there? Just curious. All of their jurisdictions say that the agreements were entered in Los Angeles. The headquarters for LiveXLives in Los Angeles and all these individuals are in Los Angeles. So they could have filed in Florida, but they all found attorneys in LA and they filed everything in LA. If they had filed in Florida, they would have argued, look, Florida has personal jurisdiction because everybody went there to work, but the agreements were signed in LA. So what are your thoughts on Judge Penny's son talking about the Britney case and her case on Twitter? I don't think it's a good look. And I can imagine any judge would be really frustrated if family is talking about their cases. They should not. And I don't recall ever seeing a judge's family pipe up. It's generally not done. Oh, good. The back end of my YouTube's working so I can pull up the super chats that I missed. Question, how does a suit get merged into the same court? Somebody would file a motion and it would get consolidated into the court with the lowest number, which would be the case with regard to McBroom versus LiveXLive. I think that one has the lowest case number because it was filed first. So the other attorneys or even McBroom's attorneys would go to the other courts and file a notice of a related case and say, hey, this case is related to that case. That judge has this case. That case is the lowest number. These should all go to that courtroom. None of these come into court for a case management conference until the end of November, beginning of December. So that should happen around that time, is that they move over there and all go to the same court. This happens commonly in like lemon law cases. You'll have tons and tons of cases arising out of kind of the same type of issue, but all different plaintiffs. They'll all just go to one court. You get this where courts just get one multiple cases that are kind of similar facts all lumped together because it makes sense. If you want to have a hearing, LiveXLive is in most of these. So LiveXLive is going to have to be in court the same day that McBroom's attorneys are going to have to be in court the same day that Taylor Holder's attorneys are going to have to be in court. You might as well have all those scheduling conferences together. And so it makes sense. Everything gets scheduled. All the attorneys show up at once. It is for judicial efficiency, and it just makes a ton of sense. So that. Claudia Garcia, thank you for the super chat. Hi, all new here. Glad I found you. Just love your personality and beauty and brains. Well, thank you. Farm Girl Night Runner, thank you for the super chat. We covered that. Portia's Rump, thank you for the super sticker. Phoebe, will you be covering Rihanna getting sued? Not just yet, but soon. We have lots. And then allegedly Angelo, I got to that one earlier, so we got it. Will I be covering Kelly Clarkson? It's on my list. So yes, it's on my list. Question, allegedly both UK YouTubers Gibb and Deji received full payment in advance of the fight. How does this impact order of priorities? Order of priorities is for payment after the fight. So if they negotiated to get paid before the fight, A, they were smart. B, that's probably where some of the investor monies went. And that doesn't impact the order of priorities because the order of priorities are from the proceeds of the fight. This is where the monies go. So getting paid in advance is not proceeds from the fight. Question, what are your thoughts? I talked about that one. Question, when is it determined if a case needs to be sent to bankruptcy court due to the money being spent? As a paralegal, bankruptcy court is a nightmare to work with. It would either be the party, in this case, Simply Greatness, filing for bankruptcy, or it would be an involuntary or a forced bankruptcy, which is the procedure we saw with Tom Girardi and Girardi Keese, where multiple creditors showed up and went to the bankruptcy court and went, this shit needs to be in bankruptcy. So it can be an involuntary bankruptcy, or it can be the party filing for bankruptcy. J.L. Halbert, I don't want you to cover Chris Chan. Please don't. It's too messed up, and his mom doesn't need the attention in her. It is messed up. So don't Google the Chris Chan stuff. If you don't know, it's okay to not know. There are some things we don't need to know that go on in the world. So yes, I appreciate that input too. Question, if Dad Spears is removed from the estate, could he still become conservator of the person again? I imagine if they remove him from the estate, they will remove his powers and appoint Jody Montgomery as permanent conservator of the person at the same time. Ashley Kelly said, question, my friend is a public defender and she's covering felonies. Yeah. How do you care for your mental health seeing so many terrible things? She's struggling right now. I'm sure she's struggling. The pandemic has been absolutely devastating, particularly for those in criminal practice, and for those who are trying to deal with it for your friend, people who are being kept in custody much longer than they would otherwise, among other things. It is very difficult. I did not do perfectly at it. I have addressed it in some other coverage, but you have to have someone to talk to who is a trained professional that you can tell them everything, because they also have procedures to deal with secondary trauma. Acknowledging that it's secondary trauma is very helpful, and treating it as such. It is a complete day in and day out work for each person to protect their own mental health when they're dealing with secondary trauma from a job. It is hard. And I think acknowledging that it's hard for lots within the system. It is not your friend. They are not weak because it affects them. They are not weak because they are emotional, and that gets kind of beaten into you as a lawyer. It is hard. Counseling and therapy are a first step. Also, plenty of sleep and hydration. Living off of alcohol and fast food is not a good way to take care of one's mental health. I've done that at points in my career. It doesn't go well. It does not go well at all. Question, what do you think about Britney Stan allegations in Twitter's against Judge Penny? I haven't seen that. I don't have thoughts because I have not seen that. Question, did you get a shiny Pacala yet? No, I have not. I have not at all. Palkia, I have not. Question, will you cover the Chicago Blackhawks case? It seems like a lot of stuff that could be blowing up. I have not even started to dive into it yet, so it's on the list. Just with being on vacation, there's a lot I haven't gotten into yet. Hi from South Africa. Love your show. Thank you. Question, if this just goes to bankruptcy, does the rest of this go away? No, it all gets pulled into all the lawsuits get stayed or pulled into the bankruptcy and resolved within the bankruptcy. So no, it doesn't just go away. It gets resolved through the bankruptcy. Question, maybe a stupid question, never, but where do you get all these court documents from? The court. I pull them from the court's website. Depending on which court, I pull them from that court's website and pay for them from the court's website. So most court websites have them as public records. I will always tell you if I can't find something, but yeah, I pull them from the court's websites. These are all from LA County, which charges more than like federal courts, depending. So, y'all, it has been almost 3 hours. I can hear Diva in my mind, even though she's at work, being like, 3 hours? Really? Really? Sorry, y'all. It was a long stream. Mods, thank you. I appreciate you. Thank you, thank you, thank you, thank you, thank you for such a long stream. Don't forget to like and subscribe. I will absolutely be talking about this more. I will be covering this case in updates. I don't expect we'll see much happen until October or November on this. The attorneys should be talking behind the scenes, but if the attitude coming from Simply Greatness and the McBrooms is, what the fuck you gonna do about it? We'll go to bankruptcy if we don't like the way it resolves, then this probably isn't gonna resolve without going to bankruptcy. Which seems to be the direction this might be going in, because I imagine there are a lot of other fighters that didn't get paid. So yeah, this isn't gonna go well. This just isn't gonna go well. Thank you all for hanging with me today. It was a long one. Thank you for being a Lawnerd. I appreciate all of you. And replay crew, if you made it this far, thanks. I know being live is a different vibe, but replaying all the way to the end, it's some fucking dedication, and I appreciate you. I will see you guys on Friday for Friday Night Live. New episode of The Emily Show dropping this week, and I will share that with you. If you're not in the text crew and you're in North America, textemily.com. We'll get you there, and you can join the text, and then you do not have to rely on YouTube to give you that notification bell, because they do not always like to do that. So I will talk to you soon. Take care and have a good one. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just textemily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.